Hey all, here is a replay version of the most recent live stream Q&A on all things Social Security that occurs every Wednesday at 1 p.m. Eastern Standard Time. So this is with all the little silences carved out of it. So I hope it's an easier listen for those who are doing the replay versus being there live. And we'd love to see you live. So feel free to pop in. Bye-bye now. Hey guys, how are you? I just want to get this set up properly. Hope everyone's doing great. It's been incredibly busy. Let me get the comments up here, see who's around. I know summertime, it's kind of weird, right? 333, I see you. How are you? And Baxter, I see you. Nice to see you guys. CG, how's everybody been? Anything crazy? How's the weather doing in everybody's respective areas? Been a couple rainy days, which we desperately needed after some crazy heat spells and storms and such, but everything's good now. Hi, Lori. Nice to see you. I don't know if we've met. Have we met? Everyone else I see here is so far who we know. All right. So I know. Hi, AF. I see you there. AF vet. A cherished veteran. Busy week. It's been some hearings going on, and it's always kind of busy when we're getting them all together in terms of finalizing the brief and all that good stuff. And then the pre-hearing stuff, and then of course the anxiety that we and the client seem to have before a hearing. So, but the hearings went pretty good. One was for a younger person, younger in terms of the Social Security disability world, but a worthy case. So, we do take them. And then I got an OTR. I think I told you guys maybe last week or the week before or recently that one of my clients scheduled for a hearing in May. It was canceled, postponed like 2 weeks before by the judge's office, which was devastating to the client. And this might be because this is actually a remote DLI case, which is another one of those more difficult cases. And she had already gone on her own and done it and lost after a hearing and even after appealing to appeals council and such. Not sure if she went to federal district on that one, but I took her up on the second attempt, and that hearing got canceled, postponed. And then by the time they reschedule it, it's October, this coming. So really upsetting to the client, and totally understandably. And then she gets one of those Social Security notices that it's being postponed again. I have never seen it postponed twice in my 20-something years doing this, and it's not even common for it to be done once. I don't know how they manage it with judges. They're going to get sick like the rest of us, but somehow they must have backups and all that. So this was really surprising. So, a little bit in panic mode because the poor client, it went from May to October. What's the next date going to be? So I hopped on the horn, as we tend to do, with that office, and someone there that knew how these things were scheduled really said, give up your 75-day notice, which that leaves it down to a 20-day notice. That's perfect. I don't even think we need that because brief had been in, and it was to do that, and then also to let them know that if they wanted to change it to a different judge, that would be fine too. So I had sent a letter in, waiving the mandatory 75-day notice, and lo and behold, we get scheduled for August 6th. So now what was going to be October before it was canceled was now working out to be in August, almost 2 months earlier. And that was great. So we were excited about that. And then I got a call. What's today, Wednesday? This might have been Monday. Yeah, it was Monday. The judge wants to know if the person would amend, we've talked about this, guys, amend her onset date to her 55th birthday because she did it far younger than that when it all started. In fact, she might have been 49. I'm not sure. But anyway, Tasha's here. She wants another nibble. That's a big one. Don't choke. And so, of course, I spoke with her, and yeah, absolutely she would amend it because she understood what that means. Plus, it's still like 3 years of back benefits. That's how much time has gone on for her. So really thrilling. Yeah, we get to save not having to do the hearing, but everything's been prepared. The massive hours to prepare the hearing had already been done, but that's all a win to me. And particularly with a remote DLI, I wanted to tell you guys about this. This individual had a DLI that's, a few years ago, end of the year. Let's say it was 2022. The individual turned 55, like 5 months before the DLI. So she gets the benefit of, for those 6 months anyway, where the law that's still within her insured status period could be used at the age 55 amount, which means even if you could do light work, according to their bizarre way of figuring that out, which we usually don't agree with. But so, yeah, so it's a age 55 win. It's going to be so much better for them financially. I know that for a fact. So I just wanted to mention that because that happens too. And the hearings went well too. One of them, I think we have an answer. One of them, we don't have an answer. But it went as good as it could possibly go under the circumstances of that particular case. So I was very pleased. Okay. Now as for you guys. Okay. So 333 said, where are you at? Can an adjudicator issue a partial decision, or will they just deny and leave it to a judge if there is a conflict with Onset? No, they can. Absolutely, they can. All the time. It happens all the time. In fact, I think Jonathan and I were talking about it recently. Well, we've talked about it numerous times, actually, when we've been together doing these live streams. And it can be very disappointing to someone who's just filed when they're like, I've been disabled for 3 years, and they gave me like 8 months ago. So I get a whopping 3 months of back benefits, even though I haven't been able to work for 3 years. And that can be disappointing. And then the temptation there is to appeal it based on the onset, which is a very tricky question. You want to look at closely before just being trigger happy appeal for it. You want to make sure you have the goods. Probably if you're pro se, I would say speak to a lawyer about it so they can at least review some of the technicals that will describe whether there are some more risky things to think about. Because the end line is when you appeal an onset, so say on initial or recon 33, you open up the whole thing for a whole new determination. They can completely say, actually not disabled at all. So yeah, it can be risky. Sometimes it's far less risk and almost no risk. And that's those technicalities I was talking about. It often has to do with the vocational profile, what was the age and all that, and also, or what is the age now? The DLI, of course, is really important. And was there a particular, you want to look in the DDE, I would say. What was the basis on which they picked that date? You know what I mean? Were they pointing to an MRI that finally showed cord impingement? Or was it something, was there something? If there is none, a lot of the times they will do it on the person did change the age category and they zap it to that. It's very frustrating when they do that. But it's the kind of thing where you're like, what's the chance of flipping them on that? So then the person has to decide, let's say the risk of it being overturned is really slim, but do they want to be doing this for another 2 years? Sometimes the having to be anal about your treatment. Now not that you're not a little anal after you win, but it is definitely not the same. I think y'all can probably attest to that, and particularly people, if anyone's in here who has prevailed, and we usually have some of our, not my winners necessarily, but people who have prevailed and they come and they tell us about it, people that are kind of regular here. So it can really depend. But anyway, you definitely want to review it with a fine-tooth comb. And as I feel like they always, the age change gives them an excuse to award, but they're saving all this money. So, it's all that kind of, negativity part attached to it. But yes, they do it all the time, 333. 333 goes on to say, also, can you explain how a 58-year-old with long-term knees, back, and mental disabilities consistently transition through steps 4 and steps 5 at initial stage? Step 4 would be, can he do his prior work? They found he can. So his prior work to them, the evidence did not show that it was too arduous for a person with his medical records to not do. Well, actually, yeah, you're saying they found he could do his step 4, his prior work, which is why they had to move on to step 5. And then step 5 is there other work he can do? If they found he could do his step 4 work, they don't really have to find out about 5 necessarily, because there's a job he can do. And it's the one he already did. If he can't do his prior work, then he can go to step 5. And I don't know if I said that backwards before. And that would be, well, okay, he can't do his prior work. It was too arduous. But can he do any other job? So can he do any other job? Now, when you're entering the 58, that means any job within, you didn't say whether he met the RFC exertional level that would allow him to work with a grid. I suspect not, maybe. But so if he's a 58-year-old with, mild long-term knees and back problems, and he can do a simple sedentary job, and he used to do a simple sedentary job, yeah, he could definitely do another simple sedentary job, right? Or that's assuming he can't do the one he had for some reason. But remember, simple sedentary job means there's no need to transition in terms of skills and such. So in terms of transferable skills. So it does happen. If they found that his evidence was so weak on the knees and the back, like he barely treated, there wasn't a lot of current stuff. Some people think that, an MRI from 3 years ago, because we know certain things don't improve, right? Back damage, but they'll rely on that. And that's not going to cut it. They're going to have to get, for a best case scenario, those updated MRIs. Too many people I see, they don't realize that they have to keep treating like they're disabled today, when they're like, I had the proof from 3 years ago. Not going to happen, right? So it could be something like that. Was it you, 333? Or was it somebody else? Baxter Taylor's in the house. Hi, Baxter. When I was a paramedic, I received an award for outstanding stroke care from a level 1 stroke center. I think you told me this before. Should I include this in my submission? No. Why would you? What's the relevance? We talked about this last week, remember? Everyone who gets awards at work, back when they could still work, doesn't have anything to do with whether you're disabled today. It really doesn't. And if you include it, ostensibly there could be a risk that, you're focusing on things that are not relevant. Why is that? Is the stuff that's relevant you don't have strong enough stuff about? You know what I mean? Because you're trying to sway them with how great you are. Sure, you were very great, Baxter. I would love for you to be my paramedic if I needed one. But when you start including things, people do it in other ways too. They'll talk about, let me give a for example. I've been working since I was 12. Yeah, not relevant to today's disability, but so you don't need to share that with them. They can't consider it. It doesn't mean anything. If you're thinking it might subliminally make them want to award you, that would be too remote, and I would say no. I would say the risk of taking up space that could be better used with other narrative is one thing, and also the risk of, why is he pushing all the things that have nothing to do with his current medical condition? Is there, like you're focusing on the things that aren't important, like you don't think you have enough of the strong stuff that the law requires, So just a thought. All right, guys, I feel like my chin's getting cut up. All right, CG says, hi CG. Hiya. CG says, are ADA medical questionnaires helpful in the SSDI claim? I guess that would depend on what's on the ADA medical questionnaire. And is it the claimant himself answering the questionnaire? Then it's not really medical opinion or findings, right? So that could limit it. If it's a doctor answering questions, and if the questions actually meet the threshold that that particular claimant in the SSD claim would need to show, or it would help them show, and that's a particular question. That's not just like well, it says I'm having a difficult time. That doesn't say it. So it has to be, know your path that your needle is going to weave through to get to disabled. And then you can figure out which questions would be relevant. Hey, Yafet, how you doing, bud? Lori says, I had my court hearing on the 16th, was wondering how you can tell if it might be a positive outcome. I'd have to listen to the entire hearing and see if there are any nuggets that so indicated. A lot of times there's not. Sometimes there is. So I can't, fabricate what might have been in your hearing. Although I could give one thing that's kind of tends to be on the side of obvious. I assume there could be a very big exception, very rare. If the judge dismisses the VE, potentially, doesn't even think he needs them, that could be interesting. Or if he asks a hypothetical, any and all hypotheticals, any and all, and usually there's just one, but any and all, if the VE says no jobs can be done, and already confirmed that that hypothetical person can't do the prior work that you had, then that's a good sign as well. And the best sign of all is when the judge says, I'm going to pay this case, counselor. Like, that's what we like to hear. But that is incredibly rare. That did happen this week, though. So that was good. But it's really rare. We like to think we win all of our cases, but they never say that. It's very rare that they say that. That might be because I take a lot of younger people and they're rarely going to say it for them because they really got to review that stuff and try to make it stick with the auditors and stuff. Hi, Lori. How are you? Kubi Dreams is in the house. Hey, Koob. Hello there. Nice to see you. Baxter says, I had functional RFC in 2018, and I reached my MMI, maximum medical improvement. So I assume you have a workers' comp case, maybe, the way you're talking about functional RFC. Like, that's an FCE, right? Functional capacity exam. That's a workers' comp thing. That's 2018. That's a long time ago. We're almost like a decade later. And I've reached my MMI, and SSA found me to be unskilled. Do I need an updated RFC? Well, if you're treating your residual functional capacity, and I assume you have a case going on, Baxter, right? Refresh me. If your evidence, you should have treating evidence where paying some doctor or physical therapist to give you FCE should not even be necessary. And it's also got its risks. If the doctors are doing their job properly, my opinion, it's me some hate mail sometimes, the stuff should be documented. Is that a little bright, that light? I don't mind that one on. So, what is that about? Was that just blinking? Or is that my eyeballs? You got weird stuff going on. So, updated RFC. The RFC is what the SSA determines you have. It's not your doctor doesn't determine it. What you're really alluding to is getting someone to test you and give an opinion about your functional capacities for various tasks. And they usually do it in the vein of the workers' comp kind of rules. So it doesn't often totally match what an SSD case would be, but that's all we got, right? If you're going to go that way. I like to see a doctor's record be really robust. I kind of wish the medical licensing boards would require a little more of them in terms of the quality of their output, but that's probably never going to happen, right? So if you are going to if you are vigorously treating now, Baxter, that is what you really need to do. And what kind of RFC limitations need to be established in those records and or in a higher for pay FCE, you got to know what that is too. I mean, if the FCE narrator says something higher than what you need to win your case, you just put a fork in it or contributed to a possible fork in it. If the judge or the adjudicator decides to believe them, think they are worthy and reliable and credible and all that. Deanna's in the house. Hi, Deanna. Big Sir Moonchild. Hi, bud. I don't think we've met, but I love that name. Big Sir Moonchild. How are you? I have a question. Don't hesitate to put it down. Baxter says, I had functional RFC done in 2022. Okay, so you had one in 18 and then in 2022. It's medical maximum improvement, and SSA found me to be unskilled light work. I don't know, Baxter, I can't tell, because does light work under the laws get you to win under your vocational profile? Do you have transferable skills? Do those count? Well, if you're unskilled, that might not matter, the last part. But light work, I don't know. If you're in your early 50s, be helpful, not for a grid anyway. RFC out, which is what we do for those that are, we always have to do that for those that are under 50 but don't meet a listing. We're RFCing. We're pounding every aspect of the RFC, all the non-exertional stuff, the manipulative stuff, the postural stuff. Our Willie's in the house. Hi, our Willie. Happy Wednesday. You too. By the way, guys, tomorrow morning I'm leaving for the calm place to work out by Harrisburg. I'm excited for almost a week. I was going to go today, but I was like, I would be racing to get here with you because I would get out of my PT. I'm lucky if I get home by 10. If I went straight from there, so let's say 10:15 and drove straight 2.5 hours to that place, it would be what? 1 o'clock? Would that be 1 o'clock? 11:30, 12. Yeah, it would be like 1 o'clock. I'd be running in the door. I'd be sweaty and disgusting. I'm kind of sweaty now. It's a little warm, but at least I'm showered, hair in a ponytail, wearing my little baseball hat. So yeah, I'm excited to do that tomorrow. And I'll be there. And then I'm either going to come back Wednesday morning so that I've got a couple hours to get myself situated before live stream, or I will come back Tuesday morning. I haven't decided yet. I think Wednesday morning will be fine. And that means my adult-ish age children need to hold down the fort and be big kids and maybe do a little cleaning, Big Sir says, I think that will be my case. I turned 55 last week and filed initially at 52. Ooh, where are you at now? Are you like waiting for a hearing, or you didn't mention, right? No, you just said hello. Yeah, it could be. And one thing I do before hearing, and any of you that have changed, well, everybody should do this. I do it with my clients whenever it's, well, almost pretty much everyone. But sometimes it's twofold. I always discuss with them, if the judge says something like, have you discussed with your client an amended onset date? I'd like to be able to say yes, so therefore I do. We discuss the fact that a judge might find that you are disabled, but not back when you said, when you thought you were when you applied, because the evidence was weaker then you finally listened to Stephanie and added a little more, and they might find finally you meet it, right? So are you willing to amend your onset date to make it your alleged onset date to make it later? And of course, if we ever say to the judge, yes, he's willing to do that, it's always with and I did this in writing this week, under the understanding, judge, that you find enough evidence to find him disabled as of XX date that you mentioned. So I always kind of put that in the record. Just, call me paranoid or overly cautious and conservative, but I don't want to ever be punked where it is said off the record to me, someone goes and amends, and then it gets denied anyway. That's not happened. So, and that hasn't happened, but it's something that I would definitely, avoid. Just a little sentence in writing, I think, clinches that. But it's something to consider, because if a judge puts you on the spot, because he wants to award you, but not as far back, you need to know, is it acceptable to you? Can you take that compromise or can you not? If you can't, then he will either have to deny you, or I kind of think if it's ethically done, it would be a partially favorable award. He's still going to give you the date he asked you to amend to, but you can't be a fully favorable. And they don't really they prefer doing, it seems to me, a fully favorable because you amended, than a partially favorable. And if there was a judge in the house right now, I would love to, retired judge, for instance, I would love to pick your brain about that, because this is, I don't know if I had talked about it with a judge or if it was where I got the idea, but I've had it in my head forever. I'm also thinking that if you have amended your onset date and now that's your new alleged onset date and you get an award, you're not going to likely have a credible way of appealing it, saying, yeah, but I really wanted it back there even though I amended. Partially favorable, you never agreed to change it. He gave you the new, more recent date. You're not happy, you could still appeal. Not that you can't necessarily appeal the first one, but you're going to look pretty ridiculous, right? That's my thought. But we review when we can see that the evidence got stronger. I'll even have it kind of noted in my brief where things occurred, and oftentimes anyway. And of course, if there's an age change, there's always an eyeball on an age category change. So you want to pay attention to that. And then think, are you willing or are you not willing? And it's really up to you, entirely up to you. Big Sir says, I've not been given a hearing yet. I'm worried about losing my onset of 2021. Well, you might want to be worried. Okay, so you've lost twice, initial and recon, and you're worried about losing back benefits when you can't even clinch disabled yet, Big Sir. So you were you're going to be 55. You were at a much more difficult threshold prior to 55. And I know what Big Sir is alluding to, guys, is that if he, his onset of 2021, assuming he filed within like a year or 17 months of that, would be all those back benefits. I get it. That's like a nest egg of, it can be life-changing, right? It could pay off your mortgage or get you into a home or, a million and one things. But I know it's really, really hard. And I wouldn't say necessarily you should agree to amend. If you know what the rules say between 50 and 54 and whether you met them. And were you actually 49 when you filed? 21? No, that's 5 years ago. Yeah, you might have been breathing down the neck of 50. Big Sir, you best know in your hand what strong evidence you had, not how you felt, but the strong evidence that you had from 2021. Did you have a ton of MRIs that showed broken back in 3 places? What did you have? And don't forget, there's 21 and a half. Like, it could be any time. Sometimes, like the one I had, I was pushing to have a before 55. The person was like this summer turning 55. So I'm like, there's no way they can deny him at 55. But that will be no back benefit to him. And of course, it'll be pro bono for me after all these years, right? So, we want obviously the oldest date we can get for our client. I thought it was really a really strong case. I thought it was decently strong for the 50 to 54 too. I knew I would be shocked and stunned if he didn't win at all at 55, but that's great. Could use the monthly benefits desperately. However, how great would it be for the guy to have $40,000? You know what I mean? To put in his savings account for a rainy day or whatever it would be. I don't even know what it would be. It might be less than that actually, but so I don't foresee. Like in certain instances, when you filed and said your onset was 21, did you treat robustly back at that time? Or was it later that you started to treat robustly? Vigorously. I say robustly a little bit too long. Something about that word, robustly. So just feel it out. If he doesn't ask you to change it and you don't change it, and let's say he awards you at 55 and you have like no back benefits, you can appeal it and just know that you're going to take it to the appeals council. They usually decline to review, but not always. Depends, if the judge did something wrong in terms of procedure, really. And then if it gets denied there, you could take it to federal district court. And by the way, when you appeal, but you won on the award that's being appealed, you still get paid what you won. So it's not like you have to appeal and be like, do I appeal and go another 3 years without getting paid? You can get paid. So thankfully, then it would really be a deterrent. I mean, there's already enough deterrence to it. Like the fact that they can open up the award that you got is a deterrent for a lot of people. Lori says, I did have an attorney. The vocational said I could not do my previous job or any work in the national economy. Well, okay. This is where I'm going to alert you that I'm not sure that's what your VE said. And the reason why I said, because you said the vocational said that I could not do my previous job or any work in the national economy. The vocational expert is never, ever even talking about you, Lori. They're talking about the hypothetical person. And if there's 2 hypothetical people, how do you know which one the judge is going to find relates to you? Now, if this is what you meant, that the VE, there was one hypothetical and the VE said no jobs at all, and I can't, and that hypothetical person can't do the prior work, well, then I would think that's a pretty good sign that you have a good result. But that's a very specific thing. Was there only one hypothetical? Was there no jobs, period, ever mentioned by the VE? Okay, so that's the only clarification I feel like I would need with that. Hey, Rip's in the house. Hi, Rip. Long time no see. It's been a few weeks, huh? Hello, Stephanie. I went out for a CE and my right hand scored an average of 10 and my left, I don't even know what that means, 10.6. The CE just wrote I had a 25% loss of strength. Okay, maybe that equates to 25% loss of strength. ALJ used that, but for my age, 80% loss. Huh? No idea what that means. I mean, I get what 20% loss of strength is, but I don't know what you're talking about with the 80% loss, but for my age. Did you get denied? Rip goes on to say, I didn't notice that until I read the CE report. Wasn't the CE required to use the test results and not his guessing estimation? His test results are in his report. So yeah, you could say that equates to a 10 equates to 25% loss. Sure. I mean, if he is incorrect about that and it's like scientifically kind of established, well, then you could have gotten a doctor, I suppose, to refute that, but that does not equal 25% by definition. And an expert, you might have to pay someone to do that, but you're saying it doesn't equal that. But who are you? No offense. Who am I? Like, we're not hand experts and all that business and MDs and such. So you would have to. And unfortunately, there's very little time to do that, because if you get evidence now that it's incorrect, that wasn't before the judge. So the judge can only be held responsible for what was before him. So if you never got a hand expert yourself, never got those estimations done yourself, then you're stuck kind of with what is there. Doesn't mean the judge is going to believe that number, but that number might not be a winning number. It depends again on your vocational profile and the other details of your case. Baxter says, how much will an organic brain dysfunction, abnormal EEG and MRI show lesions on the brain? How much weight does that carry? I would say those objective tests, abnormal EEG and MRI, and I'm not sure what you mean by organic brain dysfunction. That would have to be more specific, but those things are objective. So that would be probably an established finding, a diagnosis, a medically determinable impairment, and then the rest. So that's zero weight towards severity in a sense. But then there's discussion of what your symptoms are, presumably in those records, and what treatment has been appropriate, and whether it's worked, and that's why it goes on and on and on to see, So it shows you have something, but it doesn't mean. People might have that and be able to do a job. So it doesn't necessarily mean you're going to win just because you have that, right? It means you have DIs, medically determinable impairments. Then you have to prove they are severe, and then you have to prove they're so severe that they eliminate all work. It's almost like a 3-stepper right there, right? It's like 3 subsets of steps. Michael Wolford. Hi, bud. How are you? It's been a while. It has. Thanks for popping in. I see you around elsewhere, which is always fun. As you know, I click like a lot. Baxter says, thank you for the advice. I was trying to give a baseline on what I was before my illness. Okay. Are you talking about your paramedic stuff, Baxter? Was that you? Scrolling up. Yes. Okay. Paramedic. Gotcha. You don't need to do that. It's not going to help, and again, it's not going to help, and it takes up space and takes up their energy and distracts from what they have to look at, if they're even going to bother, or it could actually look like you're trying to, focus on things that don't define whether you're disabled today. Being a paramedic is pretty impressive as it is. So you don't have to say, and I was also the one that got the award, because honestly, a paramedic is huge, 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 huge. I love you guys. You guys are up there with my first responders. Rangel's in the house. Hi, Rangel. Hey, she says, how long should you go back on psychiatric medical records? I saw somewhere, psychiatric records. I saw somewhere that they need to consider them no matter how far back. Technically, they that's what they say. Everything you submit that's medical will be considered, but they can consider and be like irrelevant to today, So like a lot of people, you have an onset date, right? And just because I'm not talking about you per se, but any of us. Let's say a person has been getting weekly therapy for some depression for 20 years. And there's plenty of people like that. Most of them are still working, but then some things get worse, or physical comes into play. And now you've got this, and then the depression gets worse. Like, things happen. We are constantly changing. We had some changes in our house this week. I went to urgent care yesterday. But it's like, if someone had, let's say it's garden variety depression, that'll be, by the way, noted in your history and your current records. So they don't really need to see all the minutia of, psychiatric history while able to work fine and dandy. Where is that relevance? If it was a sudden, right when you file your claim, you suddenly go to a therapist for the first time ever, maybe you want to show, I've had a history, I've been, strong about it, taking care of it, I could withstand it, and now it's deteriorating. That would be different. But again, that's going to show up in your medical history. So do you want to feed that adjudicator 1,000 pages of psychiatric, therapy records for a time period he cannot find you disabled, when your medical records say, it's been getting therapy for 20 years. You know what I'm saying? Now, if it was this is the difference though, for me. If it was a complete mental claim, no physical involved, that could be a different story. Particularly if there's been, to win completely on mental you guys know how hard that is. That's why at 50, you want to throw in your physical, because none of us are perfect at 50. Well, most of us anyway. Because then you can't use a grid unless you have something physical. So, and then you throw in the mental. But if it was a purely mental case, you have to show that you can't even do a simple job of an under average intelligence person who can't deal with stress. There's jobs, no stress, no public no coworkers, and you hardly ever have to see your supervisor. So many of those mental health impairments aren't going to be triggered by going to work. You're basically doing exactly what you do at home, sitting there doing not much, but you're getting paid. So if, the kind of severity we're talking about is someone who, I've mentioned this before, and just because it's an easy example, complete agoraphobic, cannot leave the house. All visits are telehealth, and even doctor visits come to the house. That's kind of like a wild hyperbolic example, but that kind of proof of that person, if they can't leave their house, they can't go out and get one of those jobs that exist in substantial numbers in the economy, national or regional. So that heck is that? Stop that dog! Dog is under my feet, scratching. So if it's going to be totally mental like that, presumably the person has had hospitalizations voluntarily or involuntarily, not just 3 days. Maybe they've had weeks of trying to get rehabbed. You know what I mean? Find that perfect, if it exists, mental health medication combination. So be careful about what you want to blizzard them with. If you're going to send too much of something that they can't even use, yeah, they got to accept it. But if it's going to really have any kind of impact, then you're just kind of taking their focus off what they need to do. And they're human. I would just be careful. Be selective. And again, your current doctors should all have that in their record, correct? So Heather Shantae is in the house. Good afternoon, Stephanie and Tasha. Yeah. Hi, Tosh. Are you shaking? Are you cold? Do you want another disc? Or are you cold? No. I don't know if you want it. Are you going to drop it? Because the dog's going to eat it. She's a little, I don't know how she can be cold. I have a fan on up above, but I'm a little warm. See my rosiness? Hey, a new member. 2 chicks in the house. Oops. What is it? 2 chicks. I said in the house. They are in the house. This house. But 2 chicks 100. Hi. No, those 2 chicks 100. See, I can't even see. I'm talking about my glasses, by the way. They're on my head, but that's because they're not for this kind of stuff. They're for distance. Good to see you, Heather. And nice to meet you, those 2 chicks 100. I don't even think we've met, and you're a new member. That's awesome. Thank you for that. Baxter says, I see you have a good memory. My memory is gone. It's hot, muggy here in Georgia. You think I have a good memory? That's awesome. I don't feel like I do, but you know how it is. Aging is a slippery slope. R. Willie says, does being prescribed one of those weight loss GLP to lose weight and manage labs affect your case in a negative way from losing the weight? No, if I understand you correctly, I wouldn't think so. GLP, losing weight is a big thing when we have musculoskeletal problems, which is the things we need to have for those grids, right, R. Willie? And the fact that you're following the doctor recommended, trying all the different therapies for it, is just showing that it's important to you to lose the weight, if you're talking about yourself, to put less strain on those damaged body parts, right? So I don't think it's a problem. Now, when you lose weight and you no longer have obesity, yeah, that's a medical MDI, medically determinable impairment, and you won't have that anymore. But the thing you're mostly going to lose on was the damage to your joints and what it's still doing to you. So like if you lose the weight and then you're 100% and don't have any physical limitations or pain or symptoms, well, God bless, that's awesome. And that would be way better than continuing a case, right? But yeah, the obesity is not even a listing. I think we've talked about this before. It was a long time ago, and I think it even stopped before I started practicing. So they stopped that. Dang, I started in 2005, so I think it was already nixed. But it's still something very relevant. And I did a dual video a couple months ago on it because obesity can affect a bunch of physical things and possibly even mental things. But I don't think it's bad to do a therapy that's going to help you improve. I know that sounds weird coming from a disability lawyer, but it's really important that you do what you have to do and that you're comfortable with it. So if your damage is there to your body and you're treating for it, which shows that it's really limiting you and it's affecting your life, versus not treating for it and just being like, no, I don't feel like it, but it really stinks, that's what they're going to look at. Hi, Dimple. Dimple's in the house. How are you, my dear? Hello from Ohio. Sherry Romero's in the house. Hi, Sherry. Sherry says she called the hearing office and they said I was approved. Awesome. You had already had your hearing. I think I recall us talking on here about it. You mentioned. I'm so happy for you. That's a celebratory moment. I'm really happy for you, Sherry. You deserve it. And go on with that next chapter and make it the best it can be for you and everything around you. That's awesome. Terrific. Heather says, I had seen a new to me section on the SSA site for requesting SSDI file, but can't find it again. Ooh, I would love to see that, because getting the file for pro se people in particular is really, really hard. They're so slow. They're, particularly when I could send it digitally, it makes no sense, but I would love to find that too. But now that you've alerted to me that you think it might be there, I will try to find it also, okay? anybody else finds it and you can maybe post something about it in one of the comments, that would be fantastic. You want to know, can you tell me because I'm talking about contacting the field office, but if you are at the OHO, you just call the OHO. They're going to get it to you. Assuming you haven't had your hearing yet, right? And you have a case pending hearing at the hearing office. Look at your notice of hearing or their notice that they got your appeal. The OHO, one of the OHO letters, always in the upper right-hand corner. I'll make sure I got my rights and my left correct. Yes, because I mix them up all the time. You're going to see the fax number and the phone number. Call that phone number and explain who you are, and you have a hearing pending, and you need a copy of your hearing file emailed to you. If they can put it up in your SSA.gov, that's great too. But some lower levels anyway, like staffers have told people that they can't do that. I don't believe that at all, but I don't know. Some managers train their people better than others, I suppose. CJ says, Doctor out for work about LOA, leave of absence, am I right there? Or ADA, accommodations, ask about what the conditions are and the limitations are. Right. The doctor actually knows what the conditions are. I mean, the doctor fills it out for you. Your doctor is the one that puts down what the conditions are because he knows them. He's treating you for them. And then also knows what the limitations are, at least some of the basic ones. They usually don't have it that detailed because they're not on top of it. But yeah, I don't know what you were talking about before. I'm going to scroll up and see if you're connecting this to something else. And I don't even, is it going to go bonkers? Okay, your prior reference was, hi, our ADA medical questionnaire is helpful to, yeah, I always submit them. You're talking about not the questionnaire, but the doctor's filled out form requesting them. Yeah. I do think so. Now, it's not a bad time to remind you that if you got an accommodation at your recent work that you can no longer do according to you, you now have to prove that you can't do that job too, as accommodated. And that's a higher burden on you. So sometimes it's nice to not have a official accommodation and just have people be nice to you and but yeah, I think that's always very good for sure. And if they didn't give you the accommodation or you had to leave work beforehand or whatever, even better, because then you don't have an accommodated job in your past relevant work. Big Sir says, I listen to you all the time while I watch your videos. This is my first time catching you live. That's very sweet. I'm glad. Thanks. Spread the word. As Christina would say if she's here, what would she say? Like, share, and subscribe. Thank you, Big Sir. I appreciate that. Those two chicks says, howdy, fashionably late, but glad to be here. So glad to hear it. Should I call you chicks if I want to speak fast? Hey, Tracy Hearsay. Here's you in the house. Member for 1 whole month. Awesome. Hi, Tracy. Thank you. That's great. You guys know what that mission is about, right? We do have a new one, too. Slowly getting in the intake paperwork, but one of the 1%, 5%ers, I suppose we'd say. So those two chicks 100, you're John, but you're under those two chicks. Interesting. But it's always nothing wrong with being a little fashionably late here. It's totally fine. It just takes us longer to get to those questions, obviously. Some people, I don't know if they're just sitting here but not commenting or not, but we will have some people that often at the very end, and we're after the 2-hour mark, which is supposed to be when I cut out, which sometimes I don't, and then they'll throw a question. I'll be like, shame on you. Okay, one more question, guys. Then we get to it because I figure otherwise it's a whole week. Tracy Here's you says, question. I have a CE coming up. One of my main diagnoses is chronic fatigue syndrome and was just diagnosed with sleep apnea. Can't afford a CPAP. Is this an automatic denial? No. I don't know the rest of your details, Tracy. The chronic fatigue syndrome can be very disabling. We know that, right? So I think it's important, if you can do it, to find if you don't already have one, a very CFS literate doctor. It might be a rheumatologist that decided to go onto some of these, finally recognized disorders that nobody gave the time of day to before and are still very hard to prove because of the severity, because of the subjective nature of it. If there's any kind of blood markers that go with it, with any other kind of impairment, that's always helpful too. The bottom line is, though, you have to show how severe it is. Remember, it's all about your functional loss for work-related tasks. So the diagnoses are the first step to get there, but then, you have to get the rest of the way. So hopefully you will be able to do that. I don't know your vocational profile is important. Under 50, over 50. Tracy, you look young to me, so I don't know what that answer is, but that's just the picture, Our pictures can be very deceptively euthanizing. And I don't mean euthanizing with an EU. I mean YOUTH. Trust me on that one. I use those tricks. But with regard to not being able to afford a CPAP, I don't know what your financial picture is at home, but have you filed for Medicaid? Because I think it's paid for. I mean, do you have insurance? And does your insurance carrier not cover a CPAP? That seems very bizarre to me. I'm pretty sure Medicaid would cover it. So if Medicaid tells you not, I wonder what games they're playing. Where's the money for the CPAPs going, huh? Okay, so Big Sur is waiting a hearing date. Okay, well, hopefully you're still going. Big Sur, have you gotten updated diagnostics? Do they need to be updated? Are they old? Are they more than a year old? If you've got like musculoskeletal stuff, have you been vigorously going to your doctors, like a person with a lot of severe problems that can't work because of them would be doing? So make sure you stay strong on that stuff. John, okay, retired ALJ here. So glad. Late to the game. You probably missed it. I was referring above. I forget what was I asking about, guys, when I said, if there was an ALJ in the house, that would be great. We could, I don't even remember what the question was. You guys remember? And of course, I can't look it up because my stuff doesn't get taped like yours does. But yeah, it was funny because what the heck was it? I know what it was, John, or I'll call you Chicks. I don't know. Which one do you prefer? I could just say Your Honor. I was talking about my perception that a judge who thinks the person is disabled but doesn't think the alleged onset date he's not gonna find it back to death. We oftentimes get those, counsel, have you spoken to your client about amending onset date? And I'm like, yes, I have. But it was my perception that he would prefer an amended onset date so he can give a fully favorable to not doing that and giving a partially favorable. Although obviously we get both. I mean, I've seen both innumerable times. So I was just wondering, is that perception correct, that for maybe logistical reasons, a fully favorable after an amended onset would be preferable from your perspective than a partially favorable? I would assume that the decision is going to be easier because you don't have to almost make two. Because you have to do a denial on the original onset date and all the way through this date, and then suddenly so the decision is going to be far more complicated, right? With a partially favorable. And then I was wondering if another influence, since you're going to get the same result anyway, right? The same answer, the person's going to get the same benefits. Is there the fact that if a person amends the onset date, they're less likely to appeal, right? Because they agreed to the amended onset date. And if they did appeal, they'd look foolish, probably, versus a partially favorable that the person never agreed to. They might be more up to appeal, and that just makes more work for everybody. Anyway, that was what I was talking to thin air about. If there was an ALJ in the house, I would like to ask this question. So, okay. Big Sur is in the house. Anyway, it's really good to see you, Your Honor. So good to see you here. Big Sur says, I have an attorney. He filed for the hearing immediately. You only have 60 days, so it's not going to be that long of a wait, right? I'm concerned about the amended onset date. If I do that, the back pay is forfeited. Generally, that would be a yes. But here's the deal. I don't think you're going to amend your onset date unless you have an indication from the judge that he would be awarding you on amended onset date. So you're not just going to do it to do it because he's suddenly, generally at that stage of the game. Usually it's something that we can literally do at hearing. It's very simple to do. But if there's a reason, I don't necessarily think one would. The only kind of thing I sometimes will recognize, and I'll even put it in my brief, is if the person had a prior case with an ALJ denial, we filed again, they used their old alleged onset date, the one that the prior judge already ruled, and it is final that was not, the person was not disabled through the subsequent time period, then I will, if I'm on the case, I will say, technically, for technical reasons, the first date that he could be found disabled would be this date, even though he had put this when he filed, this is the day after the previous ALJ denial, etc. But think about it. I just think you need to think about it in terms of your evidence, Big Sur, because you're talking about forfeiting something that you might have nil chance of getting anyway, nil chance. So if a judge is saying, I might find you, personally, I'd have to have it really on the record, but I see the evidence is really strong here. Would you want to amend you don't, because then you want to keep appealing and then risking it opening up. Although I think you said you're turning 55 or you just turned 55. So it's a lower risk, I think. I guess from your own personal heartfelt position, if there's really no way in heck you're going to get that back pay, are you really forfeiting anything? It's kind of like I lost a lottery ticket. Well, was it a winner? Oh, I have no idea. I never checked it, but I lost it. I mean, what did you really lose? The $1 in $10 million chance that you would have won that. You know what I mean? We don't cry over that because we know that we probably would. The chance of that having been a winning lottery ticket are nil. And in a way, this is kind of similar because if you have no sufficiently strong evidence at that earlier time period, and they are pretty stringent on the 50 to 54-year-old crowd. John, I don't know. I'm sorry, Judge. I don't know if that was like that before you retired, but we talk about it a bit now, and some of my colleagues and I, that there seems to be, and this is going back maybe like 5, 6 years, 4 or 5 years, something like. I'm just trying to think when it seemed like noticeable that the age category change was being used a lot. And then on initial and recon, oftentimes not giving it to the original onset date. And I understand why that wouldn't be in many cases. I mean, I know how to look at the evidence and everything, but sometimes when I'm like, that's really silly. And then, so everyone's perception is they're just, they're trying to save the money, which I understand actually. I just wanted to make sure it's always within the confines and not just for that reason. And we all know how fragile and special those funds are, and they do need to be protected. But yeah, Big Sur, the back pay is essentially forfeited for all intents and purposes, yes. Big Sur says, I apologize for my broken text. No worries. I'm in between medical appointments. Oh, gotta love it. Just kidding. Have physical therapy ongoing. Could be seen as good evidence of severity. I love physical therapy records. I find lots of nuggets of objective, things from the therapist about this being troublesome, that being hard, when did after, like, it helps add. Of course, if they say he's a rock star and I could discharge him because he's 100% better, that would be different, but we don't really see that in real life. I wish we did. That would be wonderful, but not for, when young people are hurt and they go to physical therapy result, like most of our kids probably did at some point. I know my son did. Actually, my daughter did too. Yeah, that's for curative. The degenerative stuff, it's almost like we have to keep going forever to try to prevent the slippage, right? Like my physical therapy I'm doing now. I'm a big pusher for physical therapy. My clients think I'm the biggest nag about it. I totally get it. I am. That is true. I do it. I love it. I think it's really worthy. It's not to replace the other stuff, by the way. It never replaces updated good diagnostics and the orthopedist statements and opinions and observations and all that. Never, never, never. It is just so much good extra stuff that actually helps solidify that, is the way I look at it. Carl B says, hey there, I'm 60, had an esophagectomy. I'm butchering that, right, Carl? Done 5 years ago. You had your esophagus out or a piece of it out? Sorry. I don't mean to pry too much. I'm just interested. I didn't file for SSD at that time. If I had, I would have been awarded. Really? Okay. Does the ALJ take that into account along with my current medical and mental health? Does he take into what account? That you would have won, in your opinion, if you'd filed 5 years prior? Well, if you would have won 5 years prior, you'd certainly win now, and he doesn't need to take that into account, right? Presumably your medical records are even better now. I don't know what I don't want to say it wrong, Carl. It's so embarrassing. Esophagectomy. I don't know. What are the symptoms and limitations that stem from that particular thing? Eating is probably a difficulty, right? You have to eat special things. So then you have to relate what things would affect work-related tasks and the ones that apply to you and your particular vocational profile. You're 60 years old, you're at a good age. 5 years ago, you were 55. That was still a good age in terms of, the medical vocational rules, the grids and such. See, if your honor was here on this side with me in his little square, he could answer this question. That would be fun. So I'm putting the pressure onto your honor to come speak with you guys here on Wednesday. That would be great, wouldn't it? So your honor says, if I offered an AAOD, amended alleged onset date. So this is the judge talking, guys. I didn't pull back and deny the whole thing if the claimant elected not to amend. No, I would assume you wouldn't. And I will tell you that one thing that did happen to me when I was a newbie. So this is I don't think it was quite 20 years ago, but it was probably within my first couple of years. I was out of state. I'd gone down to Savannah for a case. Fortunately, I had a place to stay. And the judge had offered a closed period, Your Honor. And my client was, meaning he was better now, which didn't make sense to me either. Although, I wish I had the file. I probably have it, but I would review it now and see if I had a different eye towards now than I did my first 2 years of practice, which I'm sure it's far more astute now. But he offered a closed period. My guy didn't want to take it. Obviously, I do what my guy wants. And I supported him in that. I didn't think it was. And then the judge outright denied him. And the discussion was somehow off the record about the closed period. I don't know how he did that. I don't recall now. Was there a point where he said, Clara, let's go off the record for a minute? I don't know if he did that. And then he talked to me about that, which I would have had a problem with now. But at the time, not having all the experience from the last 20, it was, So I was a little shocked that he got a full denial. And some buddies with a big firm in Georgia took it up to federal court, actually. But I was surprised because I thought that was my being punked, as someone explained it to me later. So yeah, I think so. What the judge is saying here, guys, is if he said, "Hey, claimant, are you willing to amend your onset date to this date? Basically, he's saying he would never just go renege on that, right, Judge? And then deny the whole thing. Well, if you did agree to amend, but also if you did not amend, he would still be giving you that as a partially favorable. I think that's what you're saying, right? Like you're not going to get punished for not agreeing or electing to amend, which is the only appropriate way to do it, right, Judge? Tony P says, hi, Tony. I don't think we've seen you in a couple of weeks, right? I definitely haven't been to a live in a while. I know. Still watch the vids and give a thumbs up. Ah, thank you. I'm fighting to get, Otis, get down, honey. I'm fighting to get a placard. None of my doctors wants to fill it out. My leg doctor gave me a 3-month temp one. Really? And Tony, you are disabled and have been found disabled, right? You're not pending. I'm surprised. Placards are one of the easiest things to get as far as I'm concerned. So what is that about? I mean, it's usually for like difficulties ambulating, right? Whether it's breathing problems, leg problems, back problems, and you have a leg doctor. Well, then, get the 3 month and keep getting it. Eventually he'll get tired of filling it out and he'll probably get the 5 year or whatever. That's really interesting. Have you guys also had that problem? Because I'd love to learn if that's becoming a problem, because I never really thought of it as a problem, because I see it a lot with my clients, a lot. It doesn't hold, a lot of water with the SSD finding, but nonetheless, because it doesn't address the same things, but I would think you could get that. I'm surprised. I truly am. Big Sarah says, chronic L4, L5, lower back pain, neuropathy, left leg, chronic migraines, and I have been going to a variety of treatments. Correction officer for 25 years. Oh, you had a tough job for sure. And you were the one that just turned 55. Well, I mean, in my brief, and I don't know if your attorney did a brief or not, or is doing one, and I don't know, Your Honor, I'd like to know what you think about people that do briefs or do not do briefs. Outside of the quality of the brief, of course, I do them religiously, every single case, and they're time consuming, of course. I mean, that used to be the thing I took the most time with. I'm a little faster than I used to be, but it's still extremely time consuming. So I'm just wondering what you think. Like, I get the sense that some judges read them. I do mine really weird, but I do try to put like the summary on the first page, like, but I have an attachment to it. It's more for my use than anybody else's, but it helps me make sure that case is in my head like nothing for hearing my attachment A. But I feel like, Big Sarah, like, so what happened with me recently was, we don't know what date the judge is going to pick, but he did allude to the fact that he was going to pay. That's the call. I'm going to pay. And the person just turned, he's like within 2 weeks of being 55. But we really do want those back benefits for obvious reasons. And so my brief kind of put some of the stronger stuff, not really going back to when he alleged, because when he alleged was when he stopped working. I wasn't involved at the time he filed. When he stopped working, and that wasn't a bad date to put. It really was actually a few months after he stopped working full time. But that whole year he had no insurance. So there was no records for, like, let's say it was 2022 until like end of 2023. So it's something to clearly acknowledge that there was no request to change it, but I, in there, kind of highlighted where some of the really strong evidence came in of different things. So, and in my brief is about, there's a growing, at some point, it's, the evidence becomes very clear, that kind of thing. So I feel there's a very good chance it could be, and hopefully is, before 55, before now, going back maybe to 2024. I don't think even 2023 when it started might be sufficient, but I'm thinking possibly 2024 and certainly 2025. I can see 2024. Lori says sorry, Lori, going back to it, Big Sur, it might not be 2021, but what if your stuff you started getting all those MRIs in 2023? That's still a significant amount of back benefits. So just remember that each, it's a moving thing, and try to figure out where you think it's really strong for the things that are relevant for remember, you have to prove at 50 to 54, the age you were, if you're trying to meet a grid, that you are limited to sedentary or less. So where does the evidence about walking, the limitations of walking and standing and lifting come in, right? Kind of review that stuff. You can do like I do. I itemize every visit. Like, that's not all that goes to the judge, though. A lot of it does, but no, we kind of curate that a bit, but it's crazy. And that's an attachment, so it's not part of the brief, Judge. The brief stays just a few pages, because I know that's what we're supposed to do. So I'm just like, don't worry about the rest. It's just an attachment, because I need it. I just need it. I need it to be there. It's something about me, and it's in body part or system, kind of. So if all the back stuff is going to be in a section, and it's going to be chronological from most recent going back, and only the RFC limiting stuff So nothing else is going to be taking up space. It still gets, it's pretty lengthy, but just what I do. It seems to work really well. And I have no idea if they even read it, but for whatever else reason, maybe because we're more anal about it and we do more, it causes us to do more. Maybe that's why. I don't know. So Lori says, the judge asked 2 hypothetical questions and the vocational answered no to both and no jobs were mentioned. Okay. I'm 55 and a half. Awesome. 55 years young, Lori, remember. So not sure if that helps my hearing or not. I think that's very, very potentially favorable. I see nothing unfavorable about that. Let's put it that way. So those details matter, Lori. Fingers crossed for you, girl. So Miles says, what's up, Stephanie? Hi, Arthur. I'm very happy waiting for my award letter, but your information was right on point. Oh, that's good. Keep helping everyone. Medical evidence is everything. It is everything. And it is very important. And I'm sure, that's what the law says. And the judges have to, that's what they get to go by, right? Hey, Wayne Quarters in the house. Hello, Wayne. How are you? Good to see you. And I love your flag. Lori says, so does it look like it may have a positive hearing? Yeah, like I just said, I know you probably posted this beforehand because you posted that at, where are we at? Yeah. I'm at 216 and you posted that at like 130. All right, let's see if we can. Big Sur says, yeah, Lori, it sounds good, my dear. It does. Never, you can never say never, and there's no guarantees, but I think that all sounds favorable. Big Sur, I believe it was November 2022 when I first filed. That sounds familiar to at least 2 of us in this room. I was 52. My attorney, God, this is like twinsies, Big Sur. My attorney felt I have a strong case. My condition requires ongoing treatment. Would it be a good idea to get my PT notes? Your attorney, I'm sure, already has your PT notes. Are you kidding me? Ask him now. You haven't had your hearing yet. You're waiting. Your attorney's on top of this. Of course he's going to get your PT notes. For sure. Those are every single medical piece you have should be in there. Nothing should be foregone. And PT is really, I love it. I think it's really good. Think about it. And I've said this before. Let's say you have 24 PT sessions over, how many months? Well, let's say over 12 weeks. So you go at least twice a week. You've got 24 visits in a short period of time where the person is observing, documenting all about the physical, usually physical, limitations, symptoms, and whatnot. If you were to be, how fast could you get 24 sessions with your orthopedist? You're saying into the PT. It would take you, 7 years, 5 years. If you were going a lot, think about it. You just got a lot of, and granted, it's not an orthopedist, but the orthopedist relies on that information also for his, decision making. So I think the PT is really powerful. Doesn't replace the ortho, but it fills in all these gaps and questions and all this other stuff. So it is, I can't speak more about it. And no, my husband is not a physical therapist or anything. Although ironically, I do have a physical therapist in the family. Let's see. Big Source says, California is my favorite place to visit, about 2 hours south of San Francisco. Glad you like the name. Yeah, Big Sora Moonchild. It's pretty cool. Philip Walker's in the house. Hi to you too, Philip. That's a pretty cool drawing. Hi, John. Or Judge, Your Honor is what I might prefer. No sorries. I'm so curious about your screen name, though, if you care to share. Heather Shante says, you looked away and she dropped it. She did. See, I knew she didn't take it with vigor there, Heather. So she was just like trying to be polite, but she had 2 big pieces before, and that might be nap time for her. Sometimes I give her little ones and I give her 10, and then sometimes I give her the big ones because I wasn't going to be able to. I brought her in literally like 60 seconds before we started. I feel like she's been a little bit ignored, and I'm going away for a week. So, but my daughter and her are really close, so she'll take her out. Your Honor says, I have no idea how I got 2 chicks. It's JP though. Oh my gosh. Is that like a spouse's? Are you using a spouse's account? That is too funny. Don't know how I got my screen. You can change your screen name. I don't know how to do it, but people here have done it. Like sometimes they use their real name and they're like, oh, I didn't really want to use my real name. Like, change it, before you say something you regret. Rip says, my bad. It was, is it a dynamometer testing? And that's that strength thing, right? And I was diagnosed with CTS, carpal tunnel syndrome. But for a 46-year-old male, that's an 80% loss of grip strength, not 25. I can't say whether it is or not. I'll take your word for it. So what you're saying is the CE had it wrong. Now, hopefully, when that case goes to, I don't know if you said you were at hearing, you might be still at recon or initial. When it goes to the medical experts in the SSA, hopefully he will be able to realize that that's not, those 2 numbers don't jive, if that's the case. I don't know if I'll be able to do that yet. That would be nice, right? Let's see what else. Kelly McPherson's in the house. Hi, Kelly. Hi, good morning and good day, wherever you are. I'm in Pennsylvania. I have a question. You got it. I've been told that if you travel outside the USA for more than 30 days while on SSDI, it triggers you to get a CDR. Oh. I don't think so. Never heard of that. Now, if you're on SSI, it would be, yeah, I've never heard of it triggering a CDR. I'm sorry. That doesn't mean it, I don't think it does. I don't think it does. Not to mention, they're not even going to know you traveled out of the USA for 30 days, you know. And I don't even think they say, if you go on vacation for 35 days, you have to, you know, they don't have their thumb on you like that. SSI is a little different because it's welfare money's leaving it, you know, they're not going to want to send it. If you're not here to need it to survive here, they really don't want to be sending you the money for that month because it's welfare, you know. It's someone else's money, but someone on SSI can go for 3 weeks to Caribbean or wherever, France or wherever they want to go. Okay, so Big Source says, last piece, my back issues are the root of my neuropathy issues. I bet they are. It's horrible. Stems from an injury in the military at 19. Yep, that stuff catches up with us, doesn't it? When I realized I can't work by traditional means, again was in 2021, filed 2022. Yeah. Remember, just because you realize you can't work doesn't mean you have the legal evidence to show it. So just make sure it's very flashy in here, doesn't it? I don't know why. Just make sure you recognize that difference and go through your evidence from 21 and see, was it like, see, you're so close to you're so close to the problem. You feel the pain. Feeling the pain is not objective evidence, right? That's subjective, right? Not irrelevant, but it's subjective and it's, nobody else can see it. The blood markers don't show it, So if you had if you had an MRI at that time that showed severe stuff and nerve root compressions and impingements and severe spinal canal stenosis, I think 21 would be, not unreasonable to expect. And that's assuming, again, that your descriptions and everything else kind of corroborated that you could not do light work. Because remember, you were approaching advanced stage, but not yet advanced stage. So, at 50 to 55. So, or if you were 49, then it's going to be tough. But it's not so much, it's a logical, if you weren't working then and that's when you felt it happen, that's a logical place to put your alleged onset date. I'm not knocking that. I'm just saying when all this stuff gets done and they see what evidence existed then to support it at that time, that's what could be quite lacking. All right, we're at 2:25, guys. So that's an hour and 25 minutes in. We've got another 35 minutes if my voice will hold up. Big Source says, thank you for your advice and insight. Be well off. Yeah, you too, bud. Thanks for stopping in. I appreciate it. Kelly McPherson says, good morning. I've been informed that if you travel outside the USA for more than 30 days at a time, okay, this is the one we just talked about. I don't believe it's true. I've not heard that. I have not read that. That does not mean I'm correct. I haven't researched it either, but I've never seen that to be the case. So I'm thinking not. Okay. Rangal says, that makes sense, but my current doctor records wouldn't have shown it because it's from a different medical. No. When you start with a doctor, you're supposed to tell them your medical history, right? So it should be in there that you had, it should be in there. And if not, just tell them. It's like, can you add this in my history? Because I don't think you were aware. That's what I would do. I mean, the medical history, when we start with a new doctor, they always ask us to fill out the medical history, right? I mean, it's so important. I mean, super important. How many years ago was it, would you say? Was it 15 and then you're back in the saddle again? Or was it 2 years before? That could make a big difference, I think. The closer in time to when you became disabled versus just having impairments that you needed to address, but still able to work, I think is stronger than the older ones when you then went back to work, a resolution of sorts. Heather Shante says, I haven't received any notices yet. Patiently waiting as always. Submitted my appeal online. 79 says they received my request today. Thank you. Yeah, online is definitely the easiest way to appeal. I mean, it's really good. It's super good. And sometimes the mail, they will mail you something and it kind of takes a while to get there with our mailing system, right? Baxter says, 2016 neurologist notes, I had amnesia for 5 days. I have memory loss 2023. To say psychologist states I have memory loss 2026. Okay, so you have memory loss. 2026 neuropsych states I have memory loss. Is that a good timeline? Well, okay, but how extensive is it? You know what I mean? Like if someone tells you to go over there and open the door, will you forget what they said when you're halfway between here and there and go over to the kitchen? Do you know what I mean? Like, so to what extent is the memory loss there? If that's like your big disabling thing is really bad memory, everything's about the severity. Functional limitations for work-related stuff. Sir says, sorry, LOL, one more question. Always, no problem. I was issued 2 different electrotherapy devices, each way from pain management, TENS unit from physical therapy. Do you think these can be good evidence? I think they're helpful for sure. I think conservative therapies, which that would fall under, they're not invasive like a surgery. are really, really, really valuable. It shows that something was still bad enough to do that. Now, those are not, I'm not sure what H-wave is. I mean, some people go so far as getting a stimulator implanted. I always look at that as being very indicative. And I kind of hope the SSA does too, because that's going in your body, with, some people have greater success than others. Some people need it tweaked quite a bit, but I think all of those things are really important. And it doesn't hurt to show that you're actually using them at home, like the TENS unit. Like when you're at your doctor's, say, I use my TENS unit every day or 3 times a week or whatever, So it's not just that you have it, it's that you use it. Does it help? It does. It gives me relief for probably about an hour, or whatever. And so I do it, most days for half hour or whatever, just so I can have a little bit of comfort for the rest of the day, whatever the case may be. But I think it's definitely helps show, where it's waxing and waning and improving and it's still coming back as pain that's very difficult to tolerate. Baxter says, 26, where did you read that one? Okay. I know sometimes it gets duplicated, right, guys? I know you don't want me to do it. Heather says, not an SSD victory, but a huge victory for me. After 2.5 years, I was prescribed the last step medication that's been used against me to deny a potentially helpful chronic migraine medication. Oh, wow. What is the last step medication? Are you allowed to say? Hey, guys, I'm like so dehydrated. Remember, I had that PT this morning, and it definitely dries me out. It was very hard today. I was wobbling on my way out. Curious about that, Heather. But yeah, I'm glad at least they're recognizing the severity, right? Is that what is going on there, Heather? And then Heather says, I just spent another 4 full days and 3 partial days in bed during a 7-day attack, and I don't know how much more I can do it. You stick with it. They're going to find something. The migraines, I have the utmost sympathy for migraine sufferers because it is another one of those that, I don't know, Your Honor, how the SSA, it just seems like it gets blown off quite a bit. I do hammer it home, but I'm always like, we need to show other things. I've had an occasional, what I would call a migraine, although it might have just been a super bad headache that put me in bed feeling sick here and there. So I know the pain of not being able to leave the bed and the head, but I don't know if it was actually a migraine by definition. So when people have this, particularly if they're on Botox, which you can only get if it's like 15 migraine days a month, to me, that's like the insurance company wouldn't pay for it unless they're convinced, right? And I do find that the SSA tries not to acknowledge it too much. So that's something I'd be curious about, Your Honor, but I don't know if you're allowed to talk about stuff like that. Like, is there some unwritten rules of sorts? You know what I'm saying? There is a subjectivity about the pain, but when someone's been treating for 5-10 years and the medications, I know this is what they look at when they do finally do, but they have migraine journals and the medications have just been, the therapies have been always tried and not working this for some have side effects that the person can't tolerate, and then the medications getting steeper and steeper, and like what Heather's alluding to, the final step one. So I fingers crossed for you, Heather, that it helps you, because I cannot imagine having that kind of pain that I'm stuck in bed all day in my head. Well, I can't actually fathom it I can fathom it in my belly because of that gallbladder in the head. That was pretty insane. But that's the kind of thing where, well, I'm not going to talk about it because you can do it. There'll be something. I just feel like there's going to be something. Well, out of orders tomorrow is his big day. Nervous as heck. Yeah. Fingers crossed for you. Being nervous is normal. I know some people think that being nervous is a sign of their impairment if they have anxiety. And like, no, even the people that don't have anxiety are nervous. So don't hang your hat on that. Not that you were. It's just something funny that always comes up in conversation. Yeah. Fingers crossed for you out of order. Our Willie says, fortunately, I think we've obtained better MSC that will show, even with the weight loss, the impairments still prevent me from working, allegedly. It's not alleged to you and me, right? Well, I'd say we're on our way, right? Remember, there is a 12-month duration. When the evidence shows that finally shows that you're disabled, it either has to continue for 12 months, showing that 12 months from when it gets strong or it is so clear in that medical evidence from the doctors that they expect this not to be mitigated even slightly better enough to bring you to a level where you could go to work. And I'm not going to say it in those words, of course. So remember the 12-month duration. So you know me, I'm always very cautious and conservative on it, and a little bit anal and a nag, right? Treat. Heather says, I so much rather a medication to make me somewhat normal again over an SSD approval. Of course, absolutely, of course. Get out there and have a normal day-to-day and pick and choose what you want to do every day and how vigorous you want to be about it. Absolutely, and you deserve it. Tracy, that's sweet. You're 54, so you're getting there. I forget all the other details. See if it's going to be a long scroll. See, Tracy, I just want to see where we left off. Scroll. Okay, great. Tracy had said, I have a CE coming up, one of my main diagnoses. Okay, can't afford to. Well, are those the only two problems you have? Don't get me wrong, I know they're significant, but since CFS is one of those harder ones and apnea is not really often one that in alone is going to make someone disabled, I'm asking, and I said that you're 54, Tracy, right? You're a baby. But we do start to degenerate, like we get aches and pains and our little arthritis, and our bodies physically are usually not like they were when we were 20, the way I like to look at it. So, normally when we're 20, we could stand all day, walk all day, sit as long as we wanted, things don't hurt because we're just younger and that's just the way it goes. But that changes. So if your ankles, knees, back, hips, neck, shoulders, hands are not as durational, repetitive, capable, strength wise, distance, all that, speed, as they were when you were 20, then there's something going on there. And I know it's hard to think of it this way, and people say, well, I don't treat for that because it's just old age, it's just normal. Everybody's got that. I'm like, true. But you're trying to prove that you can't do a job that makes you be on your feet for 8 hours a day and you've got nothing. But you've told me that you can't do that. And the reason why it doesn't bother you is because you never have to. So you don't treat for it because it's not part of your lifestyle. But that's not what this is about. It's not about your lifestyle. It's about what jobs I'm scrolling and trying to find where I left off. So you know what I'm saying? So if you're for you to have a grid, those might not hit. I don't know if those two are going to hit exertional. Musculoskeletal will certainly touch on exertional. And you have to have an exertional limitation to use the grids between 50 and 54. So that's what I'm saying. Get your tuchus to get evaluated for, do the stand at your table for 2 hours test. Do the sit down in a regular chair for 2 hours upright without being wiggly and getting up. If 2 hours works, take a 15-minute break, do the next 2 hours. Can you do that? Can you do it all? Well, then physically you're pretty fit as a fiddle and you're going to have a tougher time. And you won't be able to use the grids. So if your other stuff is exorbitantly, wonderfully, so hugely evidentiary, you could still win, but it's just harder. So this way you're covering a different avenue of winning, which would be the grids versus having to do strictly RFC, like a 49-year-old would have to do. So, to take advantage of those rules that apply to you, there we go. Baxter says, Steph, I appreciate what you do. Thank you. Oops. Thank you, Baxter. I appreciate you. Your Honor says, I did hear that. Which thing? Now that so that's why it'd be better if you were up here with me. All right. FREVs. What does that stand for, Judge? FREVs. Fully. I'm trying to think of which question we're talking about. When I was saying, is it true? Is this everywhere? Easier for everyone. I don't even know that acronym. Is that bad? Bobby Digital's in the house. Hi, Bobby. I don't think we've met. Is it true somewhat QFR is a good sign somewhat? I think you mean FQR, Federal Quality Review. I have heard one or two people this past, year, I suppose, trying to remember, who got an FQR and then it was a denial. However, I hands down find it almost always to be okay, and it reaffirms. And I was telling you guys last week or the week before, I don't think I did it in a separate video. I think it was here that it was a week or 10 days or something. I had 2 FQR cases where the FQR people took the state adjudicator's decision of award on X date and said, no, it goes back even further to this date. So the FQR did a ton of favors financially for my guys. So how cool is that? FQR is actually being, what would be the word? Buy something. It's going to give you more if it should have been more. You know what I mean? And rarely do I see an adjudicator screw up so bad that they get overturned. But like I said, 1 or 2 people had mentioned, one maybe it was one, that they had it and they got a denial. And that's got to be frustrating. But the only little tiny bit of positivity is, well, an adjudicator thought you were disabled. So get more evidence, and then maybe you can flip it over much easier than you would otherwise expect. Just saying. So yeah, Bobby, I FQRs don't trouble me. I'm assuming too that they have FQRs on denied cases when an adjudicator denied, and I don't know how often it would be to the point of making that an award. In my case, the adjudicator wasn't denying, they were awarding, but on a much later date, much more recent date. Definitely not back to the AO date, alleged onset date. So yeah, and they pulled it back and they explained exactly why they pulled it back. I think it was in a secondary GDE. I think they gave us a second one. Like you had the first one from the adjudicator and then the second one. It was just fabulous. It was so great. Because my people were really scared about FQR, I mean, everyone's scared, right? I mean, they're like, this is like so important. And Your Honor's saying, PF, partially favorable decisions are a pain. I thought so, because you got to do a lot of extra time periods. And gosh, closed periods are probably a pain too, I'm guessing. Because you still have to have award and then a denial. Like it's like twice as much work. I'm glad I got that. I'm glad I'm right about that. Thank you. I was like, am I imagining that? Because I keep talking about it. Thank you, Judge. I appreciate it. Heather says, yes, I'm pro se, but not by choice. I'm a young buck. I will be 40 in 3 weeks. I know, a young buck, but with, you've heard me. I mean, you're here a lot, Heather, and I really appreciate it. You hear me always talk about the DL. Is that a concern for you? The DLI, Date Last Insured? And is it possible if things go sideways, case-wise, can you get a kind of gig that you can do and just make that enough to make those 4 credits and get your insured status continuing because you're so young? The judge says a bird in the hand. Yeah, a bird in the hand in this SS world sometimes is the wiser course, right? Yeah, often I think that's the case. Philip Walker says, I have a question. You bet, Philip, but it shows my name for some reason. I'm not sure why. You got to change your, yeah. However you set it up, your account, just go in there and look. Maybe even like do a Google about, or the help maybe for YouTube, like, how do I change I think it's called your screen name. I don't know if it's the same as a username. I get very confused on these things too. All these user interfaces are not that easy. Some EODs will make your eyes roll. Oh, what do you mean by that? So EOD, this is the judge, right? He doesn't know why he's called those 2 chicks 100. That's so funny, John. Some EODs will make your eyes roll. So established onset dates. Or you didn't mean alleged onset date, did you? Because the established onset date would be the judge's date, right? Or are you talking about established by initial or recon and the person appealed and then goes to hearing, not agreeing with their EOD? Just wondering. Just wondering. Dio's in the house. Hi, Dio. Nice to see you. Is this 2 weeks in a row we've had the honor of your presence? You were here last week, right? Yeah, I don't think I saw you for a while. Dio says, my current physical therapist keeps putting in her notes that I'm improving. Last time ALJ noted that. What should I do? Well, you're expected to improve a little bit in PT. And I get the sense, and I've heard this from mental health therapists also, that if you're not improving it at all, they got to cut you loose. So this is just what I've heard. Do your own due diligence, not legal advice. It's just so, a little improvement is not the worst thing in the world. If you're still got significant limitations, it doesn't mean you can still have significant limitations and they could have improved something, like your range of motion is 10 degrees more, you know what I mean? Or something. Or you're not as in pain after each session as you had been. So there's different ways to look at improvement. But I do think, I hate to say it, it's kind of like a political thing. They almost kind of have to say it or else they have to cut them loose because insurance won't cover it. Well, PT is obviously not working for them, so not doing a thing. So we're not paying for it anymore. And now you have no PT, which maybe something you're glad from a physical point of view, but from a legal evidence point of view, she still has to put your limitations, because if you were perfectly fit as a fiddle, she wouldn't keep giving you PT either. So what else does it say in those records? And there's not really too much you can do about what she says, unless you find that she's not noting, like maybe she doesn't ask you about your pain after last session, but you were like out for the count till the next morning with soreness, or, the next morning you had the soreness, whatever it is. And that's not something she asked about. Some of them do. I've seen it in records. I think it's important. You could tell her, see if it gets in the record. If she still doesn't put it in, or you can not just tell her, but you can also, I don't know if you have a portal where you can message her after the session each time. I'd be like, telling her, let's say you have PT every 3rd day, and not the day you get out, you're exhausted maybe, and you want to be honest. You don't want to be, exaggerating anything, but let's say you're very sore the following day. Just want to let you know about, the 2nd day after, I had really hard time moving around without a lot of soreness and discomfort. But by the 3rd day, I was almost back to baseline or whatever. But whatever your reality is, that's another way to get it into the record if they don't write down what you say. And that is a huge gripe on my part, is that they don't often write down what you say. I mean, not PT specifically. I think they to me, they seem almost to be better. But like MAs and the nurse practitioners or whoever's, usually it's the MAs now, and the nurse practitioners are like the doctors, right? In all of our doctors' offices. But they are often not as detailed, And with the default system of the computer programs that they use, everything is within normal limits unless they say otherwise. And if they just want to click on the one thing they heard from you when you said 3, the 2 are completely normal and fine. And so there's some things that I gripe about a lot that hopefully the medical profession will get a little more on top of. It's been going on a long time, I would say, as long as I've been doing this. I do appreciate the computerized system, though. I will say I like the fact that the portals are there, and that newer law a few years ago where the providers have to put up their progress notes. That was very invaluable to me. And they're helpful in other ways, not just getting test results fast, MRIs, I love my MRIs, but Also confirming what visits actually took place, because sometimes the client will forget to tell me about a visit, and I like to know about every single visit. So yeah, I'm kind of like that. Your Honor says, are there any residuals from the? Yeah, so we're asking this about to. Yeah, so the judge is asking, okay, who had the esophagectomy? I forget. I don't want to scroll up or I'm going to get lost in the weeds. Yeah, so the judge is also asking, what are the residuals, which is what I was asking, but I don't think I used that word, from the esophagectomy that would affect work, aside from perhaps work being a food taster or something. I would think with a surgically, I don't know. They don't take out the whole thing, right? They take out part of it. I feel for you though. Big Ta says, good afternoon. Hello, Big Ta. Good to see you here. Rip T says that, yes, that would definitely be great to have Your Honor on board. Wouldn't that be fun? You don't have to make a commitment, Your Honor. Just, one day soon and any other time after that if you would like. It would be fun. And there's super nice people here. They're just really awesome. He says, I would be happy to participate. That's so cool. I could talk to you about it on the other platform we engaged on. I'll get you my contact information, and maybe we could do it next week. Next week, I was saying I'm going to the Harrisburg. I call it Harrisburg, but it's really Perry County location. And sometimes I'll do it. I will do them there, and we could do it from there. Or if that's a good week for you, that'd be next Wednesday, 1 p.m. Eastern Standard Time. I don't know what your time zone is, or if I come back a day early, I'll be doing it from here. But either way, it works. I love portability. I work everywhere. 2024, I think I was like North Carolina, Pennsylvania, different place in Pennsylvania, North Carolina. Just because of personal needs, mostly. You had to work at various places when you had to do other things outside of work in those locations. Yeah, that would be great. That would be so great, Judge. I would love that. These guys would love it, and it would be so great to have that perspective. And you could tell, we could talk if you want, and you could be like, "Oh, I'm really not supposed to talk about that." I imagine there's some stuff that, I don't know. So there's some areas we don't have to go to if it comes up, so that at least when you do, or you could just say no comment, and we're going to know that you're not supposed to talk about that. But that'll tell its own story, right? Carl B says, yes, Mike. Okay, Carl had the whole esophagus removed due to adenocarcinoma. Due to the surgery, I suffered from severe reflux, apnea, and poor nutrition. Due to all my cognitive, due to that, well, did you also have any kind of radiation or chemo and stuff? Because sometimes those things make very long-term cognitive energy level, things like that. I guess the question is, what about, and I don't know, did you share your vocational profile, your age in particular? That would be a good starting point. How does it stop a sedentary job? Poor nutrition can add to weakness. Like where does that come in? People can be malnutrition for quite some time, and then it starts to, hurt many things. So, hey, LaRoche is in the house. Hey there, Ms. Lily. She says, hi, Miss Stephanie. I haven't said hello yet, but I'm right here with you, girl. And everyone here. God bless you. You too, LaRoche. Good to see you, of course. Glad to see you're here. Rip D says, mine was easy to get, but I also have a walker and wheelchair that I use. You prevailed. Where are we at? What was that in follow-up to, Rip? All right, you were talking about the judge, and then you said, I don't know when I scroll up, it makes me almost like, woo. The judge is saying, loved me some briefs. So you were cool about people that did briefs. I'm curious about what percentage of representatives did you find submitted briefs? I don't know, it wouldn't be exact, but you have like a ballpark idea in your head, like 50-50 or 90-10 or 1090. Big Ta says, good afternoon. Filed a second application claim. Will they use the old function and work history forms? Interestingly, I have found that they pull them up. They're still going to ask you for the new function report because this is a different time period now. I have seen them use a previous work history. I took on a case, a guy had a previous one. They didn't ask for a work history report. They pulled up his old one. I wasn't involved in that bad boy. No. I looked at it. I'm like, no, this is not going to fly. And I already knew what he did because I already get data when I take my intake. I get a lot of stuff. Clients will tell you, a lot of paperwork to get on board. I want everything. It will have to be updated here and there throughout, but it gives us such a good, and I knew that one that he did by himself was so poorly done. It was unresponsive to the questions. Some of them were blank. Some of the mistakes I see often people make is I've told you guys this before. If they had a supervisor or managerial type of job, they often will only talk about the managerial stuff. because it's, it's what we did to get the promotion. We took on, now we do the attendance for these people, and we do this, and then maybe when we make the schedule or whatever. But like, for instance, a lot of managers, particularly in retail and many, many, many areas, they're not sitting behind a desk. They might have to do some report generation at the end of the week or the day, a little bit, but they're on the floor, in the field or whatever, with the people underneath them, and doing the hands-on work too, but then also doing it's like a team leader almost on top of it. And they leave all that out. And like, that's all the stuff that shows how arduous that job was. Remind me, guys, if Your Honor comes on, Judge John will come. I was curious about his idea about composite jobs, because I don't feel like judges like them too much. So they always seem to want to smack you down for you to bring it up. So I would like to find better ways to push that point, and whether you think it's worth it or not. Anyway, for a different time. But yeah, I'll see them pull up the old one. So you know what I do? I send him a new one, and I explained that the claimant filed this years ago on his own. He had no understanding of what these questions meant. He thought he was supposed to. And sometimes I'll have them do a 795 that says, this is the accurate one. At that time, I thought you just wanted to know about what I did in my job of manager. This is the part, and I didn't, but this was also involved, because they're trying to it's almost like they're trying to show how high end they were, like they're competing for the next job, the next promotion. I'm like, no, this is not like that. You just have to be very real about the answers, and don't, you're not trying to brag or, puffery, as they say. Old function report, I think I have seen them pull them up, but not very often, because they're going to be asking for a new one. I tend to see the work history report pulled up sometimes because they're trying to avoid asking for a new one. And I'm like, oh, no, that's not going to fly with me. We're definitely setting up a new one, and it's going to be done right. And we're going to explain why there's a difference. And I mean, it's obvious. I think they know when the person does it themselves. Half the time they don't really know. Do I dare say what they're doing? I don't mean that offensively, but, Virginia's in the house. Hi, Virginia. Nice to see you again. Good afternoon. Question. Can disability lawyers drop the ball on a case knowing they had a strong case going back to 2017 with strong evidence at age 49? Well, do you mean, did they screw up? Sure. It's human error, but I don't know if that's what you're talking about. So what do you mean? They dropped the ball on a case. I mean, you have to have, as you know, at age 49, going back to 17, were you 49 back in 2017? That's a very, very high mountain to climb to prove disability. So I'm not really sure what your question's getting at. Can they make mistakes? Absolutely, we all do. But what happened? Like, I don't know the details of what you're talking about. So I think you're being very specific, right? Like something in mind. Carl B says, my hearing is set for August 5th. Very nice. I don't want to brag or anything, but my hearing for August 6th, just wanted an OTR. After we amended the onset date. Remember I was telling you? Sorry. That was kind of rubbing it in. Sorry, Carl. But I'll have fingers up and fingers crossed for you, and positive thoughts and prayers and everything else for your hearing. Lori says, thank you for your input and help. You are welcome. The judge is saying, Kelly, I've never heard of that either. What did Kelly say? I don't know. I'll leave that alone. That's kind of a private conversation. Sometimes we have people chit-chatting in here, Judge, so that's all very cool. I try to not click on those so they can continue to do that without me pulling it out. Heather says, if I was referred to neurology and cardiology for symptoms present 2 years prior and lost my job 8 months prior to discovering my tumor and brain surgery, should I add all that to my file, or would it be wasted time for both me? Let's see. An ALJ, since I didn't file for SSDI until 5 months after my surgery. Job. So you lost your job 8 months before the surgery. Did you lose your job due to symptoms that were recurring at that time? I don't really have the time frame down pat here. You get the 2 years, you had symptoms for 2 years, you eventually lost your job, and then did you get the neurology and cardiology appointments starting up before you lost your job, or was that after you lost your job? I wonder. I look rosy, don't I? Almost like sunburn, and I have not been in the sun. I'm pasty. Pasty as all get out. I'm like a vampire. Yeah, I know, you don't want to be flooding your evidence. Well, if this is close in time to when you stopped working, I don't know that it's not relevant. I mean, obviously the most relevant stuff is what's going on today. If you're still insured today, if your DLIs in the past, it's going to be before that DLI ran out. You got to raise your sharp focus on that. But are you saying you didn't submit the neurology and cardiology appointments? They were about the symptoms that grew to, then you lost your job and come back to work. I kind of think that's important. I mean, I realize it's before you stopped working. I think that's what you're saying. But it's not that much before, and it led up to it. And you have one of those, I mean, did you lose on initial and recon and now you're going to hearing? If you're in doubt, I would submit them. The judge might say otherwise. Sorry. I just think, you only have one chance to submit, and if you guess wrong, you know what I mean? Tracy says, how great is it to have a judge in here? It's awesome, right? Yeah, Judge John. Thank you, Judge. We appreciate. When I got your message this morning, I was like, That's going to be so cool if you can actually show. That would be great. That would be great. Rip says, I have myelomalacia and myelopathy. Oh no, the doctors didn't check my thoracic spine and I had mild findings on my MRI. Neurosurgeon said intraoperative findings were more significant than preoperative 1 and 2. Hopefully they have one of two findings. So technology and my doctors failed me early on. So for SSA purposes, my medical was weak early when I applied as doctor didn't fully understand conditions. You know, that's not that uncommon. I've seen that before. I've seen diagnoses take, I talked about this in one time with you guys. I think it was Sjogren's, I think. And the diagnosis took 3 years. It kept saying suspected, suspected. I'm like, for God's sake, doctors, someone pay attention to this lady, you know? So it's like my mama bear comes out with my clients sometimes. It was like 3 years. You're suspecting it. Rule out everything else. Get it done, because we ended up winning that case, and that was a remand case back to the same judge. We did win it, and she did award it, and it was when they finally said it was no longer suspected. And it was a doctor. No extra test was taken. He just said, it's clear she has Sjogren's. Why is it suspected? It literally said that in the record. Like, he was finally like, no, it's a diagnosis. Why does it say, let's stop kicking this can down the road? And that's what the date she used, which we needed, because she was a younger person when her DLI ran out, and when now we're in a remote period. But the judge, I was immensely grateful for it, but that was very annoying. So the judge gave her as of that date. Now, if they had diagnosed it early, it would have been different. You know what I mean? So if you're a judge, when you're talking about your where am I? If you're talking about your doctor, didn't check my throat spine, I had mild findings. Neurosurgeon said intraoperative findings were more significant than pre-findings. Did he put that in a letter? If that's in a letter, you could maybe use it to say, you know, the symptoms were back here. I was going to the doctors. They couldn't figure it out, but you could see here that this doctor is saying that the intraoperative findings showed what those diagnostics didn't show. I mean, the eyeballs are on it. I wonder if you could, that can help you just lend support to the fact that really back when I started seeing this. All right, you guys hear that? I have the door open too because of the AC. Sorry. Anyone in here is a dog hater. God, you must hate that. Cindig's in the house. She says, thanks. For what? There, Cindy. Thank you for being here, Cindy. T. Cash is in the house. Hello, counselor. My ear is perked up when I heard you say Botox. I always thought it was just cosmetic things, but my doctor mentioned it for pain also. Thank you. That's a big one I see for really bad sufferers of migraines. And they have to supposedly have like 15, I don't know if the protocols change, but 15 or more migraine days a month. You see that even on the commercials if they're still playing them. And that's not even fun, but I guess it can definitely cut the severity, duration, and or frequency down significantly. Let's say you have 15 and now you have 7 or 8. That's a blessing, right? And by the way, 7 or 8, if the judge doesn't disbelieve it, to me a migraine is disabling. I mean, I always say bedridden migraine. Don't use the word migraine with me if it's not bedridden. If it's just like a bad headache, call it a headache. But 7 or 8 would still be disabling, so long as you have the evidence that supports that that's how much you have it. And durational Botox, I think, holds more water than not. I mean, some judges are just not going to go with the migraine stuff. And I do find it funny when a judge would note it as a severe MDI because he kind of had no choice. That would be like probably readily appealable and remand if he didn't, and then never really specifically address any absenteeism that would result. It's almost like we got migraines, but they would never be bad enough to take you out of work. Now, if you don't have in your records that you're in bed for 2 days at a time, if it just says migraines, I can kind of understand how we might get to that conclusion because you have not suggested anything else. That's why I talk about tell your doctors if they are generally bedridden ones and for how long. Those migraine journals, I know I had a video on this, I think are very, very helpful if you keep them limited to just that. Like, and we've talked about this. You know, every day you had the migraine that's bedridden, put /B. And then maybe if it lasted 2 days, just draw the line to the second day, you know, or third day, whatever day. And then, or let's say it was for 6 hours, but then your abortive medication did the job. You could be like 6 hours for that. But then sometimes it could be like, I don't know what they call it, but the post-migraine utter fatigue where they're gonna need to sleep for 15 hours. I mean, everyone's different, right? It's very like so many things with medicine. None of us seem to be exactly the same when we catch the same thing. But I think there's an art to how to do this, but I do think, as you know, if each month is on it, like it could be in a Dollar Tree calendar, I used to tell people, like, and it's just a little legend of MB. And then MB, each day you had it, migraine bedridden. If it was migraine B, 6 hours, and then it was only 6 hours that day, but the next day you had another one. And And then I get them, like, I'll be like, okay, send them to me every 3 months. I'll then do the math, do a cover letter, and maybe a 795 where he's saying, this is my calendar where I journal this stuff, And I do the math in a cover letter that says, here's a 795 with his migraine journal. I'm just going to sum it up for you here, but it's all attached. In the month of June, he had 14 migraines, 7 of which were at least 24 hours, and the other ones were reported in 4 and 6 hours. This is a total, will you stop? Do you hear them yipping? I'm going to have to close the door. If I have to close the door, then it's going to get hot in here. Don't do that to me, kids. See, the judge just said migraine calendars would be helpful. Sumatriptan is 9 pills a month. That's the limit, right, Judge? That's what you find. That's for the most they're going to get. Pardon me, I'm just going to close the door. And then the judge also says, Botox dropped my wife. Your wife had migraines? 15 migraines to 5 or less. Wow, that's awesome. And 5 or less, if they were bedridden, Judge, bedridden days, and I know people have different, sometimes migraines are called migraines when they're not bedridden, and I understand they still are, but I kind of feel like those don't hold as much water because I don't feel like the SSA really has a big thing about headaches. 5 days or less, that would be disabling still, unless she's has self-employed where she can pick her days and all that. Wow, God bless her wife. That's got to be tough. But I'm so glad the Botox works. Tracy says, no way, Jose. I have a bunch more. What? Heather, be quiet. Sorry. The dogs are barking because someone's outside. But the live stream's over, Mom. It's 3 o'clock. So what? I also have, Heather says, I also have history, current diagnosis of ADHD, IBS, scoliosis, sciatica, flat feet, blah, 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 etc. But this migraine stumps my thoughts completely, and I can't even feel the other issues when I'm able to be active again. I am sure I'll feel more of my old issues, but I also learned how to live with them and function in the workplace. I've worked since I was 16 and never let anything prevent me from holding down 1 to 3 jobs at a time. My headache doctor said she believes I had a migraine during surgery and it got stuck in my nerves when they put me back together. Really? My diagnosis is status migrainosis, which is any migraine lasting more than 17 hours. Never imagined. You should win, Heather. I'm really sorry. Text me later, Heather. I'm just curious about something. Or text or email me. Email's on the website. StephanieJoy@joydisability.com if that helps. Tracy, here's yes, I have a bunch more issues. I just didn't want to derail your chat. I've got a pretty strong case. It's just worried about the CPAP thing ruining it. No, because that probably wouldn't be, I don't know, Judge might disagree and he would know better, but I feel like the CPAP is not one of the stronger things in the case. It's just one of those things that can fill in a little bit and help persuade an otherwise winnable case more securely, generally speaking. Favorable. So your wife had a claim. Is that what you're saying? Yeah, I would hope that would be favorable. You know what I wanted to ask you, Judge, too, if you know about? We can get the waterfall chart that shows these many cases when, were awarded on initial, denied. Here's the recon of the ones of the initials that appealed for, reconsideration. Here's the ones that were awarded, here's denied. Well, the whole waterfall chart, right? I think it goes up to appeals council or down to appeals council. Do they have anything? I have looked and I haven't found anything, and none of my colleagues seem to have. I want to know the age groups. How many people are 55? I'd like to know 60, 55, 50, 40s maybe, or maybe 45 to 50. Maybe you can shove everything else in one. I don't know. But does the SSI, I noticed it seems almost like purposely don't share that. And I suppose you could do a FOIA, but then you would have to figure out how to organize all the information. I don't know. Or maybe you wouldn't get the FOIA. They'd be like, yeah, we don't have it organized that way. Why wouldn't you? It's so relevant. The reason why they make the grids, right, is reflective of the importance of age. So I'm curious about that. I'd also like to know if they have stats on represented versus unrepresented claimants, because it's my firm opinion that represented people win more. Because if they have a witch of a representative who's going to nag them to get certain follow-up, they're going to do better. And if they don't have anyone doing that, it's going to be like me when I would join a gym. That lasts about 2 weeks, my whole life. And then I wasn't really doing anything very worthy, which is why I have my PT now. I call it PT for physical therapy. It's actually personal training, but that's because I'm so sedentary. My butt was going to fall off. I sit so much. So I'm like, I got to do this. It's an investment for sure, but it's better than paying copays, right? And it's probably less than physical therapy copays in the end. I think I'm just doing it all year, so it's going to be kind of crazy. Hits for Life says, after 8 years of multiple remands, I got partially approved as of July 2022. Awesome. Long journey. Just sad that I'm losing 4.5 years of back pay. Yeah. Oh, 8 years. Was that a long time ago, Hits? Or did you just get approved? Because that is, if it's July of 2022 and you were just approved, that's 4 years of back pay. Yeah, the first 4 years you didn't get, but do you see the difference now in what kind of evidence strength they needed to see in order to put it over the hump from very impaired? But there's some jobs they could do Favorable decisions. Huh. Lardog. Lardog. Hi there, Lardog. Hi, Stephanie. I had nerve damage after hernia mesh removed due to infection. My goodness. That's why I don't want anyone going inside. Then had a TIA. Oh no. I filed for disability and went to step 3 the first day. Is this a good sign? I think you're still at the field office. You just filed and it says step 3? Because if you just filed today, well, if you went to step 3 the first day, I don't think they have it all together that fast. I don't think. At the field office. You have to check certain things, and it usually takes, it's a very good time, a week, to get it up to the medical office, where then you would have the different steps, the sequential evaluation steps. And it annoys me that the field office calls things steps down there, and then when the legal steps are the sequential evaluation process done, initial recon medical office, and then the judge has to go through the sequential evaluation process when he, to come to his decision. So I don't know if you were at the medical office, you'd get a letter, them kind of introducing that you're there, and you'd probably, I don't know if what you'd see in your messages with the portal, with the SSA thing, but in very quick order, you're usually going to get a function report sent to you to complete, and then it's up at the field office. Up at the medical office. Might not have an adjudicator yet. Sometimes I think they might be. I could be wrong, because I know that one office was in Georgia. It was pretty cool. I saw the guy, and before there's an adjudicator, they make sure other things are done, so the adjudicator doesn't have to worry about it when he's doing the other stuff when he gets involved. And it might have been sending out the function report and the work history report. Might have been. I'm trying to remember. But it was kind of cool. I thought, they're kind of like some of the busier work for a person who's not at adjudicator level can do that. Maybe it's ordering some stuff. Maybe. I think so. Maybe the HIPMERs. Those are those automated medical records requests the SSA can do with certain entities that you might treat with that have an arrangement with SSA for that. It's pretty awesome. Baxter says, psychologist states severe difficulties, rote tasks, neuropsycho. Rote tasks are very difficult. That means very simple tasks that, don't take a lot of thinking, not a lot of complexity, right? That's kind of important. It's difficult. If it said you could do them, but no more than that, that might not be as helpful, depending on your vocational profile. Hits for Life says, I was 37 when I applied. That was the 8.5 years ago. Yeah, it's young. They get disabled too, though, right? And now you're still well under 50, right? And so you won, what'd you say you were? Yeah, I guess you were in your 40s when you won. Early 2022, were you in your early 40s then? Now you're in your late 40s. Mm-hmm. No, I'm glad you won. Lardog says, I'm 61. Yeah, that really wouldn't make a difference with the time frame, though. Did you talk to your lawyer? They'll know. Because if you're at the medical office, they can get into the electronic files, finally, and see it there. They can't see anything until the field office moves it to that step where they're going to do the sequential evaluation process to make the decision. Field office is more like an intake. They collect the minimum mandatory stuff to get all the categories. When is the alleged onset date? Is that one possible? They might even dig into, does it look like they're working SGA? Oh, we got to send them an 820 or an 821. That can happen early on. That can also happen later if it kind of reveals itself later, even if you're at the medical workup office. Heather says, I have faith in my family and friends to give me something I can get paid to do during my decent hours to make some money and push my DLI. House sit, hamster sit. There you go, pet sitting. Particularly the ones that, like you said, you just got to be there to feed, water. Big dogs can be a problem. Maybe don't do that, Maybe a cat that's, an occasional scooping of the, stuff. Sacred Instruments Jewelry says, hi, chat. Well, hi, chat yourself. That is so funny. You just said, hi, chat. We use that word a lot. We actually call a friend of ours sometimes, hey, chat. I don't know why. It's really me and my kids, my husband. We're a bunch of weirdos up here. Yeah, the EOD. So, Judge, you're saying the EOD makes people's eyes roll or makes your eyes roll. But the EOD, so you're saying the DDS is RFC and EOD. So that would be when they were awarded, though, by the DDS on recon or initial, right? And they appealed to you. And then you were like, yeah, that EOD is craziness and it should be older. Do you ever find that? Did you ever have to reverse somebody? Yikes, the DDS. Yeah, the RFCs. Well, we always disagree with an RFC. Otherwise, we wouldn't be here. Heather says, thank you so much, Judge. I've been on Sumatriptan in the past 2 years, but rarely take it because it provides no relief. There you go. I know. So if you do take it, you're like, please, just this one time, provide relief, right? On a wing and a prayer. I have a huge list of medications I'm on, have been on. I also have migraine logs. Awesome. Did you submit them because your doctors have them? Now, I sometimes like I said, submitting, yes, with the 795 and stuff to the judge. And it could also be sent to the down below. I just don't think they're going to look at it. I just don't think so. I could be wrong, but I don't think so. So that would be something I would send to the judge with the 795 and maybe my cover letter summing it. So, he doesn't necessarily have to, although I'm sure he will. But I don't feel like the lower levels would look at it. They're really more like checkbox people, I feel like. And the judges have all that extra discretion where they can use their brains a little bit more, right? Read between the lines, they don't have to see it in black and white to know it's so. The migraine logs, I don't know if you said you have them. Have you sent them to your doctor? And again, I would probably do at least a page a month, a page on a month. So you're not giving them all this extra volume. Judge John says, I certainly hope you can find something that will get that level of improvement, Heather. Fingers crossed. Yeah, it's a hard one. Yeah, it's hard. My headache neurologist, this is Heather, has documented 30 headache days per month. Whoa, with 3 to 4 multi-day migraine attacks a month based on my headache migraine logs. So really, when you're here, it's a good day. Fair to say? Or you wouldn't be here unless you're having the headache ones, kind of always kind of there or often there, and then the ones that stick you in bed. Is that what goes on? Yeah, you're so young. I know, but that doesn't feel young. Judge, you're EST. Okay, me too. I forget if I saw that on your thing. Rip is saying, I think someone needed a disabled parking permit, but permanent, not temporary. If you're asking about what someone was asking about, yeah, Rip, they were saying that their doctors just don't want to give them. The most you would give was 3 months. I don't know if that's how it starts, though. I will say I should pull back on what I said before. Do they always start doing it unless you're over a certain age, maybe, with only giving it 3 months at a time? If they're treating you and thinking they can fix your leg, your back, or whatever, they might be like, I'm going to give it to you for 3 months because we're doing surgery. Just wondering, because if they give it to you for the 5 years, which I think they tend to go for, it's like saying what we're going to do and get paid royally for is not really going to do too much. See, he needs it. So just wondering, just popped into my head. Could there be something like that? So they're going to keep it kind of short until everything's exhausted and then maybe. But you can go and do the 3 months, like I was saying, and then just keep redoing it. And it's a pain, but it's that mountain we climb, right? Reps submitting briefs, less than half. Interesting. Okay, and the judge, I think, is saying 30 days outside the country. You're saying you believe, or is that the one about the CDR, Judge? They're going to get a CDR for 30 days? SSDI, not, interesting. Guess I haven't had any people get it on that basis. I didn't know that, if that's what you're saying. Heather says, you may not make it to this way down here. Can you believe I'm still here? I know it's 3:30, 2.5 hours. My throat is raw. But yes, I saw neurology and cardiology 2 years before surgery. I lost my job due to cognitive issues and speed. You're already going to fail, Jay. I would include it. Shoot it up there. It can't hurt. You know what I mean? It kind of shows where it started, maybe. It might already be in there. Have you looked at your file? Were you the one asking about it? Have you contacted the judge's office? Can you email my file? I need to see if, what all evidence is in there to see what might be missing. So definitely send it to you. Rip says, yes, it's documented in a letter, but not being able to work and dealing with household stress. Wife working around the clock to keep us barely making it and then being denied constantly is really hard. I know. You're definitely not alone, but that doesn't make it easier. Nathan's in the house. Hi, Nathan. I don't think Matt, nice to meet you. How does complex regional pain syndrome fare in SSDI cases? I have not had a lot, but I've never lost one of them either. So I think if it's very well documented, because it's kind of one of those a little different, it's a sympathetic. I think SSA people tend to be very sympathetic to it. And I didn't have to go to a judge either. Not a lot, though. A handful, I'd say. So they're treating vigorously for it. They're trying to solve it and everything else. And usually that's not the only problem. So, you know what I mean? So don't forget any of your other impairments. They don't have to prevent all jobs, each impairment. They just have to limit something that you could do that a job might require or some jobs require. Then I think it's kind of relevant. Hey, Furry Plant is in the house. And I'm sorry if you have that CRPS. It's not fun. 550 gems. What does that mean? See, I don't even know what all this stuff means. Sorry. But thank you. That sounds nice. I appreciate Furry. Haven't seen you in a while. You okay? Hope everything's good. So we're going to try to get to the end of these guys and then blow on out of here. Talking about the migraines, Judge John says 5 days most likely would be disabling if the typical treatment is necessary. Yeah, that's what I'm saying. Like you're off task for sure, right? Absenteeism. And then it's the proofs, right? It's like, is it a durational thing or like they have to, it just seems like when we get it taken seriously, it's because the person had quite a duration of really, I always even tell people, like, if you've got a migraine specialist, PCPs, squat. You obviously need a neurologist, but even like a migraine specializing neurologist. And there are some out there, or they claim to be, whatever, but they take them very seriously and they seem very diligent about it. Yeah, I know you meant migraines Judge Victory Weber. Hi, Victory. I don't know. Did we meet? We might have. I'm not sure. Would documented impaired gait and balance issues with testing show extreme fall risk plus documented slips and falls knock your RFC to sedentary? I think it could help for sure. Definitely can help. Will it? And we'd like to think so. Is it documented once? Remember, it's durational, repetitive. It's going to make it stronger than showing up 18 months ago one time. Are the falls? I always say to people too, like, if you fell, I realize if you didn't really hurt yourself, you're not going to go to the ER. It's a fact. So unfortunately, we're not going to have that ER proof. But did you report it to your doctor through the portal, or fax it, and hopefully it'll get in the record and just say, I don't think I need a follow-up appointment because fortunately I landed on the grass or, I missed that rock on my head that was sitting there. But do you know what I mean? Like maybe to get it reported, so the frequency of these things are also known, even though you don't have a doctor's appointment for it. I was not hurt, but my legs gave out again and I fell on Saturday, Judge, in front of this entire picnic of people and they all rushed over and I was so embarrassed. No, you know what I mean? Keep them informed. Fett is in the house. Hi, Fett. I definitely don't think we met. I filed a claim in October of 2022. Denied. I was removed from my job. One first disability. Okay, I'm glad you have that because OPM approved and backdated it before the MSPB hearing. They just ignored grid. I was 52 then. I just filed again. Are you still insured? Do you have when's your DLI, Fett? Your dog is cute. What a cute little dude. Filed a claim in 2022 because we're at 2026. And if you were a pretty good solid worker up until 2022, agree going forward, 26. End of 2027 might be the best you got going, right? So you gotta win. Did they ignore the grid or did they find that you didn't prove that you were limited to sedentary work? Remember, first disability is going to be something different. So it doesn't really necessarily ask the same questions. Same like VA and all that. Judge John says there, are you on the CPAP? It's not going to be the big hoorah, right? Ooh, Rain Gal's asking, Heather Shante, have you been evaluated for EDS? Ehlers-Danlos syndrome? Is that what we're referring to? I don't know as much about it. It seems to be a changing landscape, but I see it more and more and more. I do have a few clients with it amongst their impairments. And it's hard. It doesn't seem like treatment for it is readily available. So the evidence there is not as robust, but I understand it's very painful. So all this stuff is so unfair. Anyway, Judge John says, I honestly don't know, Stephanie. Sorry. I don't math. I forget what my question was. Oh, that was probably those. Well, yeah, I'm sure you didn't do it with your cases either. The percentages, I mean, honestly, I could do it with my own caseload. I just won't have the time to do it. But I wanted to know about that. I think you're talking about how many people under 30 get denied or awarded? How many people from 30 to 40, and then the over 50s and those. Yeah, I just think it would be fascinating to learn. But it could, the realities could upset people, even though it's common sense realities. Like I'm pretty sure more over 55s win per capita, percentage-wise, and maybe number-wise, than under 30s. It's, just stands to reason. And honestly, rightfully so. I mean, if you're going to apply the laws, right? Sacred Instrument says, I was approved for both on Recon June 16th. Woo! Just recently. Good for you, Sacred. July 8th, SSDI called me needing bank info for payments. How long was the wait with 3 years back pay? Shouldn't be long. July 8th, give them till like August 8th, and I would follow up. Sometimes it gets a cog in the wheel at the payment center. Now, the field office, as I understand it, is not the one that makes those payments. I think they have more control over SSI. Sometimes it's like some sort of cog in the wheel up at the payment center, whichever one, I don't know if it's Baltimore or wherever. And I'll call the field office, and they can't do anything, but they can shoot them over a message. So sometimes they'll do that for me, like it's like an email or some sort of thing that they do. And if it goes, I would say if you've provided everything you're supposed to provide and you still don't have it after, I would wait till at least 2 months. Keep them on their toes. I wouldn't hesitate to ask your congressman to just do a congressional inquiry just to make sure that's on its way to getting paid. And a lot of times when they get that, they're going to, oops, let's press that button and shoot the money out. And then they've got your bank info. That's been the 8th. What are we at now? The 22nd? Yeah. A little less than 2 weeks. So that should be coming. Sometimes it's really fast and sometimes something just gets in the way. I don't know what it is, but I'm really glad for you that you won and that you got a nice chunk of change coming your way. Just gives a little breathing room, right? Heather says, right, I was talking to Rain Gal, I don't want to interfere. Sacred got his SSI. Okay. I will say this, when it's SSI and SSD concurrent, you got a little extra for the SSI, I'm thinking. It does take a little longer because they have to figure out all the SSI first and confirm that there was no extra income for this month and blah, 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 blah. Then the SSI, whatever month was due for the SSDI, the first month due, SSI gets shut off. And then if any SSI was paid for the months that now are covered by SSDI, they have to now pull that out and subtract it from your SSDI. So it's two different places are doing the two different payments. So the SSI has to finish up entirely. So that's a good sign that you got the SSI. So we know that's done. So now the SSD, but I was still the time frames I mentioned before. I would still hold true to them. You know, like you don't want to hold a whip over them to get it done in a day. You know, they'll throw something out like there's 8,000 less workers. Yeah, but half of them were doing squats. So is it really a big deal? I don't think that's the problem because this has been going on long before that happened. They like to hang their hat on that though. Now it's like, please spare me. But so I use those time frames, and if it's not paid, it probably will be. But if not, I would reach out to the congressman. 2 months maybe. Heather Shante says surgeon couldn't safely remove the carotid artery optic nerve areas. It grew from 24 to 25. Oh my girl. After surgery, so I had 29 rounds of radiation earlier. I'm hopeful for you. You've got all that. Make sure you got all that evidence in, Heather. If you don't have your today's hearing file, call the OHO today. You can leave. I won't be offended, I promise. Go call the judge's office and get that email to you. Tracy says, Heather Shante, she's talking to Heather. Yep. Judge John says, I should say that I only speak for myself and my opinions might not be right. Me too. I can't give legal advice, so don't rely on my opinions. Me too. Seek representation if you have any questions. Me too. I echo that sentiment. Absolutely. Rango says, gotcha. You can look up Healer Daniels, and bendy bodies to learn more. It's multi-system. That's very nice of you to share that, Ring. John Tay says the radiation. Sorry, my eyes are totally whooped. Yeah, it's been long. We're almost at 3 hours. See, we always go overtime, Judge John. I'm trying to heed my friend Jonathan. He's like, it's 2 hours. We're done. But I don't do it late at night like he does, except when I visit with him. So it's kind of easy for me to slack off. Ooh, but I do have a date at 4 o'clock. Oops, I am gonna have to close it down. All right, let me see what we got going on here. I'm actually meeting a friend out, guys. Happy hour, a little break. Haven't done it in months. All right, let's see. Our Willie says, wouldn't you know I had to go into my appointment as you replied. Make sure, like and share. Thank you, our Willie. Tracy says, all right, I'm going to try to rush through these guys. Bum rush here. All right. Thank you, and you're welcome, Sacred. Yeah, all right, so real quick. Sacred saying I did not get approved for monthly SSI, but I know the back pay amounts for both. The reason why you don't have the SSI is because for all the months from the time you're entitled to and getting paid the SSDI retroactively, you're not eligible for SSI for that month because you had too much income retroactively. So even though they may have paid it all up, then they have to take that part out of the SSDI if they paid for you when it was now no longer in retrospect with the SSDI eligible. But one good thing, if they're doing your SSI on a prorated basis, you can call them and say, I want all the SSI if there was more than 2,900, because they do it in a third, and then a third 6 months later, and a third 6 months later that. And that's to protect SSI people from having too many resources, countable resources. However, for a person that's getting SSDI and no longer SSI, that doesn't apply anymore because they're no longer going to have to meet the SSI rules. Thank goodness. I'm so glad you have the SSDI, Sacred. So you can call them and say, I'm on SSDI. I'm not on SSI anymore. Can you please send me the back pay in full? That's if you're getting more than 2,900. Okay? I don't know if you are. Heather Shante. Thank you so much for everything. Stephanie, Judge, and Ringal. I greatly appreciate you all. I will email you a short message when I hop off here, Stephanie, so I don't forget. Yeah, I probably won't get it today. I'll be driving tomorrow, but I'll see it tomorrow or tonight when I get back. I'm always checking in. A lot of my clients know. Sometimes I'm like, messaging at 10 o'clock at night in the portal, of course. Okay. Yeah. You could even just say, Heather, you could say your YouTube username that I see right here, and I'll know who it is. That's probably the best thing to make my dumb little brain connect. Rip D, thank you as always. Take care, everyone. You too. Thanks, guys. Fet was saying he was a city letter carrier 23 years. That's not sedentary. That's right. I've represented and currently represent a few letter carriers, U.S. Postal Service. So it's all that walking, I'll tell you something. It does our bodies. I don't know what our bodies were made to do, but sometimes I don't think it's. Well, maybe it's not the lifting. I definitely don't think we're made to run a lot. Joggers and stuff. That's why their knees go bad, right? All right, guys. Good to see you. And Judge John, thank you so much for visiting. That was awesome. That's really made it extra special. And everybody else, I hope you check in on the 12 p.m. daily recordeds. Sometimes there's splices of these with a little extra that we've done. That's like, well, this addresses it more deeply. Other times it's an ad hoc one, like I did one the other day on the The new SSI, it's kind of like a repeat bill attempt to try to increase the SSI accountable resources up. So we touched on that a little bit. But the live streams here, I love seeing everybody here. So next Wednesday, I'll be here, come hell or high water. And the 12 p.m. support the channel, which, as you know, support the 1%, 5% emissions. And I know I have that posted somewhere, and I don't even remember where because it's when I first started this channel. But if you want to learn more about that, that's great. The memberships do too. But the monetization from the dailies are what are probably the most, and you know, it's a small channel, but it makes a big difference because we probably have, not that we could ever take a huge amount of pro bonos or the 1%, 5%ers, but it's probably up like 25%. So it's pretty awesome. All right. Thanks, guys. I appreciate. Have a great week. Everyone be safe, and I hope everybody's weather is good. Have a good one. God bless, guys. Bye-bye.